Yeah.
Of activities that I think any of us would think a president needs to engage in order to fulfill his Article 2 duties. Yeah. And particularly in a case like this one, I want to pick up on something that the court said earlier about the distinction between a public official acting to achieve public ends and a public official acting to achieve private ends. As applied to this case, the president has no functions with respect to the certification of the winner of the presidential election. It seems likely that the framers designed the Constitution that way because at the time of the founding, presidents had no two-term limit. They could run again and again, and were expected potentially to want to do that. So the potential for self-interest would explain why the states conduct the elections. They send electors to certify who won those elections and to provide votes. And then Congress in a extraordinary joint session certifies the vote. And the president doesn't have an official role in that proceeding. So
Dreeben keeps trying to talk about the particular case here, but I don't think they were interested in discussing the particulars. They were just looking for the limit on this particular power.
It's difficult for me to understand how there could be a serious constitutional question about saying you can't use fraud to defeat that function. You can't obstruct it through deception. You can't deprive millions of voters of their right to have their vote counted for the candidate who they chose.
Thank you, counsel. Justice Thomas? Justice Alito? Could we just briefly review the layers of protection that you think exists? And I'm going to start with what the D.C. Circuit said. So the first layer of protection is that attorneys general and other Justice Department attorneys can be trusted.
Is he going to talk about the public's perception of improper actions, or is he going to undermine the entirety of the DOJ? Here we go. Or is he going to undermine the entirety of the DOJ? Here we go.
Other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
How robust is that protection? I mean, most of the vast majority of attorneys general and Justice Department attorneys, and we both served in the Justice Department for a long time,
nice.
are honorable. There have been exceptions, right?
Oh, he's going.
Federal prosecutors.
There have been rare exceptions, Justice Alito, but when we're talking about layers of protection, I do think this is the starting point. And
I think it's always good to call into question, like, what could a corrupt official do? That's totally fair and important. But I think you have to be careful here because I think the implication that a charge here could be like fraudulent, that's a pretty big claim, because we're not just talking about one prosecutor. You'd be talking about really the entire institution of the DOJ, because it would be for a case this big, right? The attorney general is signing off on it. All the prosecutors are signing off on it. All the everybody like relevant to the case is signing off on it. Like, you'd have a huge issue of corruption here, not just merely. So this protection is probably a bit more robust than Alito's questioning is suggesting. But it's still a valid question, I guess, to ask.
Yeah, and I was also, when I was reading the brief, I was a little unsatisfied with the DOJ's brief, because they basically dealt with, in a footnote, whether or not the president could be held liable under state law, because there's something between like 2,300 different prosecutors in this country. And as long as you had a jurisdictional nexus, could you prosecute them within the scope of their official acts? And the idea is that there are certain federal laws that are making those official acts illegal. And obviously you still have to deal with the supremacy clause argument, but it's not 100% clear that you wouldn't be able to find some prosecutor on some state level. So I'm not sure it's necessarily just the DOJ. And even if it is just the DOJ, when you're switching between parties, you're replacing the entire upper leadership of the DOJ with a new political party. And you're replacing every single U.S. attorney, all 94 of the U.S. attorneys, with new people. It's common for the president to fire all the U.S. attorneys and get new ones. So I don't think there's as many institutional barriers as the DOJ likes to suggest.
Is that normal that when you swap out your attorney generals, you're swapping out all of the attorneys as well beneath?
Yeah, it's pretty typical that the president fire. I'm pretty sure Obama did, and I'm pretty sure Trump did. There's the U.S. attorney for each of the district. There's 94 federal districts, so there's 94 U.S. attorneys, and they're all political appointees. So it's not uncommon for the president to fire them all and hire new people completely.
Gotcha. Okay. Josiah says they all usually resign as a custom. Okay.
That too. Yeah.
Resign as a custom. Okay.
That too. Yeah.
Well, I'm going to talk about this in the abstract, because what is before us, of course, does involve this particular case, which is immensely important. But whatever we decide is going to apply to all future presidents. So as for attorneys general, there have been two who were convicted of criminal offenses while in office. There were others. A. Mitchell Palmer is one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are two officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could just, the point that I wanted to make about this case does go to the general proposition.
Hold on, real quick.
The allegations about the misuse of the Department of Justice to perpetuate election.
From Twitch, so you might only be able to stream on YouTube.
Fair enough. I'll stop streaming on Twitch. Fair enough.
Sure. Okay.
Fair enough. I'll stop streaming on Twitch. Fair enough.
Okay.
Office. And Justice Alito, if I could just, the point that I wanted to make about this case does go to the general proposition. The allegations about the
there were others. A. Mitchell Palmer is one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are two officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could just, the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the Department of Justice functions in the way that it is supposed to. Petitioner is alleged to have tried to get the Department of Justice to send fraudulent letters to the states to get them to reverse electoral results.
Yeah, I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand jury.
So Dreeben is so Alito is asking, okay, well, the DOJ, as Uncivil Law pointed out, has political appointments and everything, and who's to say that they couldn't like corruptly bring charges against a former president or even a current president, and now you have no protections except for the very narrow things defined in Article 2 that the president could do without, fearing prosecution from even ignoring all the states from his own Department of Justice. And then Dreeben's response is basically, well, if we look at the particular facts of this individual case here, you can see that somebody did try to weaponize the Department of Justice, which Trump did, and the Department of Justice actually rebuked him here. The William Barr, and then the acting AG and the acting deputy AG. Was it Clark and Rosen? I don't remember the two names of them, but technically they were pushing against him here. So Dreeben is saying that, well, look, if you look at the facts of this case, what actually happened was exactly the opposite of what you would expect, which isn't technically a refutation of Alito's concern, but I mean, is a specific example of it going a different way that Alito would predict here. Rosen and Donahue, gotcha. So
juries will shield former presidents from unwarranted indictments. How much protection is that?
Well,
Rosen and Donahue, gotcha. Okay, so let me back up a little for this.
I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand juries will shield former presidents from.
One of the things that Dreeben is...
I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting gate.
I mean,
one of the things that Dreeben is bringing up here that I think is really important to consider, and Alito's questions and response are good, but some of Alito's questions and some of the questions on the other end, I think imply that our criminal justice system is either incredibly reliable, or at the very least they imply that when a high level of politics is involved, that you maybe can't necessarily rely on what their decisions would be. Dreeben's response is to say, as I think he's about to explain, and he kind of said here, is like, well, listen, it's an indictment, okay? There is a probable cause standard. A grand jury has to find the indictment credible. The prosecutor has to decide to bring these particular charges. There are steps that happen before any random charges are just brought before somebody. So, we've got a process for this. And Alito is essentially saying like, well, okay, but it could be corrupt, or maybe it's not necessarily the case every time. But you have to be really careful, I think, going down that road, because it's like, well, hold on. Because as a citizen of the United States, I would feel like, wait, you're telling me that this whole federal prosecution system is so fucked that I can't rely that indictments that come out of grand juries, that they haven't even met like probable cause, or I can't rely on that. Wait, well, what the fuck? If it's not good enough for the president, why the fuck am I subject to the same court system? That sounds like bullshit. I think you have to be careful when you go too far in that direction.
Yeah, well, I mean, the standard for an indictment from a grand jury is really low. You only need a majority of the grand jury, and they only have to get to the probable cause standard. It's really, really low. So you only have to, it's the same evidence effectively that the police make when they arrest. You just have to have a suspicion that this person did it with some evidence that they're responsible. It's an incredibly low standard. So it's hyper unusual for the DOJ not to get an indictment out of a grand jury. It's almost trivial.
It's the standard.
For the DOJ not to get an indictment out of a... Hold on, I can't hear it.
like the probable cause standard wouldn't protect here from frivolous criminal allegations. Well, wait, doesn't that mean the probable cause standard should be changed for everybody? Why am I, as an ordinary citizen, subjected to the probable cause standard for an indictment if a particular politician isn't, you know?
Fair.
Particular politician isn't, you know?
Fair.
Evidence, and they're not going to get out of the starting gate.
I mean, there's the old saw about indicting a ham sandwich.
Yes, but I think Justice
you had a lot of experience in the Justice Department. You come across a lot of cases where the U.S. attorney or another federal prosecutor really wanted to indict a case and the grand jury refused to do so.
There are such cases. Yes, but I think that the other
every once in a while there's an eclipse too.
Well, I think that's for the most reason prosecutors have no incentive
this is
to bring.
Oftentimes brought up for FISA courts and other courts as well, where people will accuse. Sometimes people will accuse some courts of being a rubber stamp, like, oh wow, you brought this before a judge, and of course a grand jury said yes. Like obviously the grand jury is going to say yes. The standard is very low. Like obviously this is bullshit, and the federal courts are a joke because the conviction is so high. But the counter argument to that is, well, of course the convictions are so high, they're not going to bring stupid cases in front of a judge in order to have a jury rule on them, because they know that the standard of evidence needs to be very high for a conviction, so they're not going to waste their time on dumb cases. Now, where the truth is, I'm sure is somewhere between the two of these. I'm sure there are some dumb cases that are brought, but also I doubt they're just bringing any case. Like if ideally, if you're bringing a case before a judge, or if you're trying to get a charging document, right, you're not just looking for probable cause, even though that's the standard. You're hoping to convict beyond a reasonable doubt. So the evidence that you either have or you hope to gather through the if you're charging somebody, you can still do discovery after. The evidence you're hoping to get is that you hope that you can prove beyond a reasonable doubt. So ideally, that's what prosecutors are working with in the back of their mind, not just enough to get the indictment.
Yeah. I think I finally got the stream set up on my side, so that's good news too. Yeah.
Okay. Indictment.
Yeah. I think I finally got the stream set up on my side, so that's good news too.
Okay.
Yeah.
Cool.
And secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right, then the third level is that former presidents enjoy all the protections afforded all criminal defendants, right? And we've discussed that. And that may be true at the end of the day, but a lot can happen between the time when an indictment is returned and the time when the former president finally gets a vindication, perhaps on appeal. Isn't that correct?
It is correct, Justice Alito, but I think that we should also consider the history of this country. As members of the court have observed, it's baked into the Constitution that any president knows that they are exposed to potential criminal prosecution. My friend says after impeachment and conviction, we don't read the impeachment judgment clause that way, but it's common ground that all former presidents have known that they could be indicted and convicted. And Watergate cemented
and still come across this, or still come out of that thinking like, oh, well, every president knows that they're completely and totally immune from all criminal prosecution and actions while president. That seems really hard to get away.
Because of the impeachment clause?
Or no, just because of Ford's pardoning and Nixon's acceptance of the pardon seems to imply that an ex-president knows that they could become liable for criminal charges, right? That they were always exposed to that, even while president. Seems to be the case.
I think it's kind of a mistake to read too much into the pardon and as much as the DOJ seems to suggest. I mean, I'm not sure it's an acknowledgement of anything other than they wanted to moot the issue so that they could move on. I don't know that anyone necessarily thought that there was liability. They just wanted to avoid the problem, so they created the pardon to avoid the problem.
Yeah, maybe, but the fact that there is even a potential problem that exists seems to indicate that people are operating with the assumption, this customary assumption that like, I might be exposed to some sort of criminal liability, no? Because I'm pretty sure that pardon like killed the ongoing investigations and everything as well.
Oh, surely did,
right?
yeah.
Yeah. So the fact that investigations were happening where you could have potentially been indicted, yeah, I agree with you. It doesn't like close the book on it, but it feels like it points more in the direction of, there might be criminal liability even when acting as president, rather than there is no criminal liability. There might be criminal liability when acting as president, rather than there is no criminal liability.
President Nixon and H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation.
I mean, Mr. Sauer and others have identified events in the past where presidents have engaged in conduct that might have been charged as a federal crime. And you say, well, no, that's not really true. This is page 42 of your brief. So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? Couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes, given this court's decision in Trump versus United States, in which Trump versus Hawaii, excuse me, where the court said Korematsu is overruled. I mean, President Roosevelt made that decision with the advice of his Attorney General. That's a layer of safeguard.
Is that really true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
So I think that there is a lot of historical controversy, but it underscores that occurred during wartime. It implicates potential commander-in-chief concerns about the exigencies of national defense that might provide an as-applied Article II challenge at the time. I'm not suggesting today, but the idea that a decision that was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Lanier that the right have been made specific so that there is notice to the president. I don't think that would have been satisfying.
All right, well, we could go through other historical examples.
The historical examples that they're touching on and the responses here from the litigator for the special counsel are really important, because what he's trying to demonstrate is when we're charging Trump with a particular thing, we're trying to explain why this couldn't blow up to encompass literally any action a president could take. So when they touch on historical examples, for instance, here, the internment of Japanese Americans, they're saying like, oh, well, couldn't this have been a crime? Wasn't this an obstruction against rights or a conspiracy against rights? Like, why would he not be charged? And then the response being, well, look at these other protections that I talked about existed before. You know, he did this on advice of his legal counsel. He did this on the advice of the DOJ. Like, nobody was telling him that this would have been an illegal thing. Like, this could have been under the powers of the president during the war times, the commander-in-chief. He was protecting the country. That there are a lot of different layers that would have applied in those historical examples that would have shielded them from criminal prosecution. Whereas on the Donald Trump stuff, for his actions, for the federal case, you can't really find those same compelling arguments. So he's trying to draw a difference there in how it would protect future presidents. Because remember, the big thing here that the defense, that Donald Trump is trying to point out in his legal counsel, is they're trying to say, what we don't want to happen, and we should all agree on this, you never want a president who's trying to make a decision in the best interest of the country, not making that decision because it's not in his personal best interest. You never want to have a confliction between a president thinking that he might face criminal liability for a decision that he should make for the protection of the country. And that's what a lot of these kind of like limiting principles are coming down to is, well, what type of criminal liability could the president face if he's making decisions that he is truly in good faith believes he's trying to do for the good of the country?
Or even with mixed motives, which also presents a problem because the president might have multiple different motives, and some of them might be self-interested as well. So how do you unpack that?
Sure, yeah.
Different motives, and some of them might be self-interested as well. So how do you unpack that?
Sure, yeah.
The relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the attorney general that something is lawful, is that an absolute defense?
Yes, I think that it is.
Really?
That something is lawful. Is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief.
It's like if you get an opinion from the attorney general, it's lawful. It's an absolute defense. I'm like, really?
Well, he says that, but I'm sure what he means is this wouldn't apply to what's that word? Menace?
Mens rea.
No. Fuck, I keep forgetting this. It's like our domestic version of like use Kogan's. So many times with this fucking term again. I keep forgetting this stupid fucking term. Malum in se.
Oh, malum in se. Yeah, it just means bad in and of itself.
Yeah, like I don't think that legal advice or legal counsel would absolutely absolve him for those types of acts. So, for instance, like I doubt the president could ask the DOJ head, like, "Hey," or the Office of Legal Counsel. I don't think he could say, like, "Hey, can I go and stab this person in the throat because they, flip me off?" I doubt it would be a defense there. He said yes, but there's no way that he means that. But maybe they'll get into it more or less.
Okay.
Be a defense there. He said yes, but there's no way that he means that. But maybe they'll get into it more. Let's check.
By estoppel. This is a due process doctrine that we referred to in our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
And so I think a constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once-in-history prosecution.
On the question of whether a president has the authority to pardon himself, which came up earlier in the argument, what's the answer to that question?
I don't believe the Department of Justice has taken a position. The only authority that I'm aware of is a member of the Office of Legal Counsel wrote on a memorandum that there is no self-pardon authority. As far as I know, the department has not addressed it further, and of course this court had not addressed it either.
Well, when you addressed that question before us, are you speaking in your capacity solely as a member of the special counsel's team, or are you speaking on behalf of the Justice Department, which has special institutional responsibilities?
I am speaking on behalf of the Justice Department representing the United States.
Now, don't you think we need to know the answer to, at least to the Justice Department's position on that issue in order to decide this case? Because if a president has the authority to pardon himself before leaving office, and the D.C. Circuit is right that there is no immunity from prosecution, won't the predictable result be that presidents on the last couple of days of office are going to pardon themselves from anything that they might have been conceivably charged with committing?
I really doubt that, Justice Alito. I mean, it sort of presupposes a regime that we have never had except for President Nixon and, as alleged in the indictment here, presidents who are conscious of having engaged in wrongdoing and seeking to shield themselves. I think the political consequences of a president who a right of self-pardon that has never been recognized, that seems to contradict a bedrock principle of our law that no person shall be the judge in their own case. Those are adequate deterrents, I think, so that this kind of dystopian regime is not going to evolve.
All right, let me end with just a question about what is required for the functioning of a stable democratic society, which is something that we all want. I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where
the unlimited side on the other end, where like you could commit unlimited illegal actions in your last week or two as long as you get out of office where they can impeach you, I think is far more worrisome than this. Like, because the question here, like Alito asks kind of a good question, but the reality is that like in that world, there are so many other things that would happen anyway. So if Alito is implying here that like, well, if you're worried about losing an election as an incumbent and your opponent can just now prosecute you as soon as you leave office, wouldn't you do everything to stay in office? Well, that type of opponent was coming after you anyway. I mean, like there's a million other illegal things they could do if you lose the election regardless. Like let's say that you hit this shielded criminal liability, which they're implying, well, Alito, I wouldn't say Alito's implying you should have it, but Trump is implying that you should have that shielded criminal liability. Let's say that you leave office and then the next president comes in, you're like, okay, whew, well, thank God the Supreme Court protected me from being charged with a crime. Well, what say like you're literally walking out and then the next president comes in, he just stabs you in the neck. And it's like, well, you can't charge you with a crime, so fuck you. And, you know, Congress isn't going to impeach me because everybody hates you anyway. Well, you have like the exact same issue that comes up here. I think that I agree that, no, I don't even agree that this is a serious concern. If this was a serious concern, it would manifest in so many other ways that would just fundamentally break our government. And I don't think that you can protect yourself in written law from every single potential bad act. You can only hope that you've got a good enough system of checks and balances that if somebody is trying to act improperly, you've got other people that will catch it. But yeah.
I'll tell you what, though, any person with assault would I would recommend that you pardon yourself on your last day of office, just because every lawyer would always tell you to take advantage of such a thing. It's like, oh, I have an option that absolves me of any potential criminal liability, no matter what it is. Sign me up, man. Let's sign that thing every single day of the week and twice on Sunday, man. So yeah.
Can you pardon future uncharged crimes? Is that possible?
You can't pardon future crimes, no. But you could pardon yourself for everything that happened while you're in office, because you just do it like January 20th, 11:50 a.m. Just sign that piece of paper, man. You know, it's like yeah.
Yeah, but I'm sorry. Let me be more specific. Can you pardon yourself from uncharged crimes? So let's say you.
Yes, that you can do. You can pardon for uncharged crimes. That's clear.
Okay, so if you murdered somebody on the 19th, on the 20th, you could pardon yourself from it, even if you haven't been charged with it yet.
Correct.
Okay, interesting. Okay.
I mean, as far as the federal law is concerned, obviously.
Wait, what did you say?
I said as far as the federal law is concerned, because the president can only pardon himself for federal crimes.
From federal, yeah.
Obviously.
Wait, what did you say?
As I said, as far as the federal law is concerned, because the president can only pardon himself for federal crimes.
Yeah, sure.
It's the functioning of our country as a democracy. And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito. There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So there was an appropriate way to challenge things through the courts with evidence. If you lose, you accept the results. That has been the nation's experience. I think the court is well familiar with that.
Thank you.
Justice Sotomayor? A stable democratic society needs the good faith of its public officials, correct?
Absolutely.
And that good faith assumes that they will follow the law.
She's going to bring
Correct.
I don't think that you can design any system of government that is completely, you could actually. It would have to be a totalitarian dictatorship. The only system of government that would be completely and totally foolproof from bad faith actors would be dictatorships, because whatever the guy at the top says is, and that would be the way that it's supposed to work. So you can't break that system. But any democracy or any other system that has checks and balances theoretically could be broken by enough bad faith actors. There's no way, you shouldn't even try to design a government around that. You just want enough checks and balances such that your system still works with reasonable speed, but also has enough different layers of protection that any reasonable attempt to do something undemocratic in a democratic system has a very difficult time manifesting. But you can't foolproof it. It is a democracy by definition. Has a very difficult time manifesting, but you can't foolproof it. It is a democracy by definition. You can't.
We have a judicial system that has layers and layers and layers of protection for accused defendants in the hopes that the innocent will go free. We fail routinely, but we succeed more often than not. In the vast majority of cases, the innocent do go free. Sometimes they don't, and we have some post-conviction remedies for that. But we still fail. We've executed innocent people. Having said that, Justice Alito went through step by step all of the mechanisms that could potentially fail. In the end, if it fails
all
completely,
these other mechanisms are failing.
It's because we've destroyed our democracy on our own.
Like a single Supreme Court decision is not saving you. If a new president coming into office commits to wanting to murder or do something crazy to the last one, and if enough people sign off on that decision, a Supreme Court decision is not going to save you. I mean, look no further than the idea that theoretically a president could just say, if he's got enough in the Senate to go along with him, like, oh, well, we're going to put 50 new Supreme Court justices on the court who all agree with me. And it's like, oh, well, fuck us, right?
Yeah, I mean, it's particularly given the National Security Act. The president basically has the authority to assassinate people under the National Security Act. And so if you can get enough people to sign off on the decision, then, you're probably good.
Yeah.
You can get enough people to sign off on the decision.
Yeah.
Then, you're probably good.
Yeah.
If it fails completely, it's because we've destroyed our democracy on our own, isn't it?
It is, Justice Sotomayor, and I also think that there are additional checks in the system. Of course, the constitutional framers designed a separated powers system in order to limit abuses. I think one of the ways in which abuses are limited is accountability under the criminal law for criminal violations. But the ultimate check is the goodwill and faith in democracy. And crimes that are alleged in this case that are the antithesis of democracy, that subvert it, undermine that.
An encouragement to believe words that have been somewhat put into suspicion here, that no man is above the law either in his official or private acts.
I think that is an assumption of the Constitution.
I don't really like that phrasing, like no man is above the law, because it sort of ignores that based on your status or your position that you have rights to do things that other people don't do. I mean, just the simplest example, like you live in a home. You have the right to exclude other people from the home. Like anyone else who comes into your home, you could arrest that person for, breaking and entering or anything else, but you're allowed to be there. So you're exempt from the law because it's your house. And so, I mean, it's like,
because the law, all of that is things like private property and all that are clearly enshrined in the law, like your rights and what you're allowed to do there. It doesn't put you above the law at all. You just have different like special permissions that are granted to you, but all of this still squarely falls underneath the law.
Yeah, well, that's sort of what I'm saying. I mean, the office of the president carries with it a whole bunch of powers because it's the office of the president. So if you were to reach the conclusion that the president, through his official acts, has immunity of the law, it's not because it's above the law. It's because the law itself gives him the authority to do the thing. That's part of the legal conclusion. So I don't really like that phrasing that he's above the law, because if he were to do things in his official capacity that other people couldn't do, it would be legal. Therefore, he's above the law. I don't like that. That's what's being argued, and I don't like it.
Well, but it's important. I think it's important to understand when the president is acting in his official capacity in a way that can never be questioned. Are these just like the narrow things provided for in Article 2, or is there a much broader base of actions that should never be under criminal review that the president can take? Because I think as an American citizen, I would very much feel like the president is above the law if he exists as what is essentially a king that is unindictable for any criminal consequences for things that he does while president. If every single action he takes as president could be seen as like in service of the office, that's how I would feel, right?
Well, I'm certainly up for a discussion of what is within his official acts. I think that's a different discussion. But so you have two different discussions perhaps happening. Like, assuming it's his official acts, does he have immunity? And then the separate question of what are his official acts, which I think is also a separate question.
Yeah, but the issue for Trump's counsel here is the argument that he was making is even if you commit clear crimes, when they're conjoined with official acts, the official acts can't even be brought up as part of the charges. So a lot of the questioning in the first hour of this, I'm unfortunately through it, you can rewatch it, but the questioning had to do with, let's say that the president accepts a bribe in order to appoint somebody. Would you consider that an official act? And the Trump's defense says, well, no, I wouldn't consider that an official act, which sounds good. But then later on, the question came up of, okay, well, if you're going to charge the president for accepting a bribe in order to appoint somebody, are we allowed to talk about that appointment at all? And he said, no, you can't even bring that up. Well, then it's like, and then the phrase that was used commonly over and over again was, well, now you've got a one-legged stool. How can you charge the president with the crime of accepting a bribe if you can't talk about what he accepted the bribe for? How does that even work? And it feels like Trump's defense was playing a sneaky game there of like, oh, yeah, well, of course, private actions are bad. But if they're connected with any official action, those official actions are never allowed to even be mentioned in front of a jury because they're unquestionable powers like conferred to the president, which would essentially mean he's above all criminal prosecution when doing anything ostensibly connected to the office of the presidency, I think. Actually mean he's above all criminal prosecution when doing anything ostensibly connected to the office of the presidency, I think.
First, on the small category of things that you say have absolute protection,
yes,
that they are core executive functions.
Yes.
What are those small categories?
Pardon power.
Pardon? Veto?
Veto, foreign recognition, appointments. Congress cannot say you can't appoint a federal judge who hasn't received a certain diploma or hasn't achieved a certain age. There are a few other powers.
Is Commander-in-Chief?
Commander-in-Chief is on the list, but I want to add to my answer on that Congress has substantial authority in the national security realm. Congress declares war, it raises armies, it has power over the purse. That's more. So
that may be viewed as not really in that core set of functions, which nobody has any power but the president over.
Yes, I think that there may be some aspects, like directing troops on the field, in which the president's power is completely unreviewable.
Okay. Now, in the next category, where we've left the core set behind,
yes,
but we're still in the world of official actions, and that's where you say there are various statutory construction rules that might come into play.
Correct.
But you have characterized those as something different from just saying, oh, look, the statute doesn't say the president, therefore it doesn't apply to the president.
That's right.
So I wanted to give you an opportunity to say, how that would look, how that analysis would look in a given case. And in the course of responding to that, I'm sort of thinking of something like the OLC opinion, which says bribery. The president can be tried and convicted of bribery, even in the part of the bribery statutes that do not say the president. Why is that true?
That is true because there is no serious constitutional question that the president needs to engage in bribery in order to carry out his constitutional functions. And the Office of Legal Counsel pointed out that bribery is enumerated in the impeachment clause. So it falls outside of anything that could be viewed as inherent in the need of Article 2 to function.
Do you think the premise of that OLC opinion was that the bribery was simply not official?
No.
Or is the premise that the bribery was official and still the president could be prosecuted for it?
I think that bribery is the kind of hybrid that illustrates the abuse of public office for private gain that we think is paradigmatic of the kinds of things that should be not held to be immune. In a bribery case, the public official cannot extract the bribe without the official power to offer as the quid or the pro, I guess the quo, actually. So it really is a crime that can only be committed by public officials who misuse their power. And it was one of the things that was most mistrusted. Many of the acts that are charged in this indictment or that would violate federal criminal law similarly involve the misuse of official power for private gain.
So if you were to say what the line is in this category, like when it is that the statute should be understood as precluding presidential prosecution and when it is that the statute should be understood as allowing it, what general principles should guide?
So the general principles, I think, kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity. The Office of Legal Counsel said this infringes.
That's a word.
Blood relation.
Oh, Jesus Christ. Okay. Consanguinity.
Yeah.
In fact, being descended from the same ancestor. Okay.
Yeah. Blood relations. It's used for estate purposes too, so yeah, it's used also for like estate purposes. So you're trying to find an heir. So like your child is 1 degree and your parents are 1 degree, and then your parents' brother is 2 degrees, and the table of consanguinity. Okay. It's great.
Gotcha.
Yeah. 1 degree, and then your parents' brother is 2 degrees, and the table of consanguinity. It's great.
Gotcha.
I think kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity, the Office of Legal Counsel said this infringes on a very important appointment power of the president, the power to appoint federal judges. It cannot be presumed that Congress intended to do that because it would raise a very serious constitutional question. The president is out. Then there are categories of statutes where the president is in, like, for example, the grassroots lobbying statute. The Office of Legal Counsel wrote an opinion about that, and it said, for the president or other public officials to go out into the world and to promote their programs, that can't be what Congress intended to prohibit. What it did intend to prohibit is using federal funds to gin up an artificial grassroots campaign that gave the appearance of emerging from the people, but it was really top down. And the Office of Legal Counsel said the president and officials who carry out the president's mandates are subject to that statute. So that's a more nuanced one. And the third example that I will give you is the statute that would permit prosecution for contempt of Congress. The Office of Legal Counsel concluded that a good faith assertion of executive privilege as a reason for not providing information to Congress would preclude prosecution because Congress cannot be deemed to have altered the separation of powers in such a manner. I think OLC probably would have gone on to say if Congress tried to do it, it would be deemed unconstitutional. But again, this was a statute that did not specifically name the president. There are only two that do that. So the entire corpus of federal criminal law, including bribery offenses, sedition, murder, would all be off limits if it were taken to the extent that some of the questions have suggested. And for the general principle, does it raise a serious constitutional question? And if so, to what extent? Can it be carved out individually? And there may be some instances where the statutes here could be carved out and a particular act could be found to be protected. Or does the statute across the board in such a wide range of applications, somewhat analogous to overbreadth analysis, infringe on the president's power so that we're going to say that the president is just out?
Now, that set of issues, they seem important and may occasionally be difficult. They also seem not really before us in the way Justice Jackson suggested earlier. What do you do you think they are before us? We should just clear it up. Here it is. We have a case. What else could we do? How should we deal with this? That there are these lingering issues that go beyond the question of whether there's the kind of absolute immunity that the former president is invoking.
So I think the court has discretion to reach that issue, even though Justice Jackson is totally right. It was not raised in the district court, and it was not raised in the Court of Appeals. And the analysis that I would use to get there is a fusion of a couple of principles. One is the court has often resolved threshold questions that are a prerequisite to an intelligent resolution of the question presented. So in a case like United States versus Grubbs, for example, the court reached out to decide whether anticipatory warrants are valid under the Fourth Amendment before turning to the question whether the triggering condition for an anticipatory warrant had to be in the warrant. So that's one principle. And then a precedent that bears some analogy to this is Vermont Natural Resources Agency versus United States ex rel Stevens. It was a key tam case, and the first question was whether a state agency was a person within the meaning of the False Claims Act, and the second question was whether if the state agency was 11th Amendment immunity kicked in, and the court wrote an analysis of why it could reach both questions. The reaching the person question didn't expand the court's jurisdiction, and it made sense as a matter of constitutional avoidance to do that. There are some considerations that cut against this, and I want to be clear that for overall government equities, we are not wild about parties who raise an immunity case that can be presented to a court on an interlocutory appeal and then smuggling in other issues. So we would want to guide the court not to have an expansive approach to that issue. But the final thing that I would say about this is part of our submission to this court is that
I can't follow any of this.
Article 1 branch and the Article 2 branches
what they're running through now, or what Dreeben was running through before, were examples of one of the arguments that's brought up by the defense by Donald Trump's counsel is the idea that, well, the criminal statutes don't involve the president unless there's like a specific call out for it. And I think Dreeben's counter is that, like, well, that's ridiculous. There's only a few that specifically mention the president, and there are so many other federal statutes that clearly apply and obviously apply. And if you look at the Office of Legal Counsel, their legal consideration and the opinions that they're writing seem to imply that that these legal statutes do apply to the president, and it would be strange to assume otherwise. And then Dreeben right now is running through examples, because I think it's Kagan asked Dreeben, do you think that the court should even consider this, right? Because I think a lot of people are looking to how broad, like, is the Supreme Court of the United States seriously going to answer the question of, does the president have broad criminal immunity in the United States against all criminal prosecution once he's out of office? That's a question. And obviously, it seems like the special counsel wants that question answered, but that's a massive constitutional question. The Supreme Court probably doesn't want to answer it. They're probably going to kick it back, because I don't know if they want to even get involved in this. But Dreeben's trying to make the argument, well, I think you guys should answer it. And then he's giving prior cases. Well, here are other cases where the Supreme Court considered important constitutional questions that weren't even directly before the court. And this has happened before, obviously, too, but that's just what they're running through right now. Before the court. And this has happened before, obviously, too, but that's just what they're running through right now. Who would make the decision if not the Supreme Court? Well, the idea, the hope is that these types of things just don't come before the court. That maybe there's a very narrow decision reached by a lower court saying that, like, well, Trump wasn't acting in his official capacity as president, obviously, or gets defeated for some other reason, and then the court doesn't have to consider it. Just because this is such a monumentally huge fucking question that maybe the court I don't know, actually, on civil law, how does the Supreme Court decide whether or not they really want to answer a really, really fucking difficult question? Like, how do they make that determination?
So general rule is there's the canon of constitutional avoidance. So the Supreme Court and the lower courts will try to go out of their way where they can to resolve a question on non-constitutional grounds if they can, and they will interpret statutes if there's a reasonable way of reading it of avoiding the constitutional issue. The other, so assuming they can't do that, so that would be like one of the things they could say is like, oh, the statute doesn't say it applies to the president. So that would be like a statutory construction.
And the answer, I assume the reason why for that is because you don't want every single year there to be like 50 different readings of the Constitution.
Yeah.
You hope that everything is consistent internally and as read by letter of the statutes or letter of the Constitution or the amendments, that the stuff is answerable right there, and we don't have to constantly reinterpret the Constitution, because it would undermine the legitimacy of the Constitution and the court.
Yeah, exactly so. And so if you can't do that, then the Supreme Court will, they often kick the can down the road. So you could very easily see them coming up with a decision that's somehow remanding for further decisions and letting the lower court try to take another crack at it. So it is not atypical for the Supreme Court to defer, sometimes multiple occasions, sometimes frustratingly, I might add. But this is a completely novel question. They're faced with it for the first time, and they'll be reluctant to come up with a really strong answer if they can avoid it. So,
yeah, yeah, okay. Yeah, okay.
Is that Congress actually did apply these criminal laws to official conduct. The court may wish to exercise its discretion to resolve that issue.
Okay, I have one last set of questions, which has to do with the official, unofficial line. Yes. And you heard Mr. Sauer's responses to both Justice Barrett's questions and my questions about what he thinks counts as official here and what he thinks counts as unofficial here. And I'm just wondering what you took from his responses, and also how you would characterize what is official and what is not official in this indictment.
So I think petitioner conceded that there are acts that are not official that are alleged in the indictment, and we agree with him on all of that. I think I disagree with him on everything else that he said about what is official and what is not. Organizing fraudulent slates of electors, creating false documentation that says, I'm an elector, I was appointed properly, I'm going to send a vote off to Congress that reflects that petitioner won rather than the candidate that actually got the most votes and who was ascertained by the governor and whose electors were appointed to cast votes. That is not official conduct. That is campaign conduct, and I think that the D.C. Circuit in the Blasingame case did draw an appropriate distinction. A first-term president who's running for re-election can act in the capacity as office seeker or office holder. And when working with private lawyers and a private public relations advisor to gin up fraudulent slates of electors, that is not any part of a president's job. So
there's an allegation to do with the removal of a Justice Department official. Is that core protected conduct?
We don't think that that's core protected conduct. I don't think that I would characterize that episode quite that way. We do agree that the Department of Justice allegations were use of the president's official power. In many ways, we think that aggravates the nature of this offense.
What?
Seeking as a candidate to oust the lawful winner of the election and have one self-certified with private actors is a private scheme to achieve a private end, and many of the co-conspirators.
No, I was just confused when he was talking about the officials with the DOJ, because the president, when they were talking about, like he was trying to get the Department of Justice to do things, and they didn't want to do things for their own reasons, but the president is, of course, the head of the executive branch, and the Department of Justice does work for him. So even if the Justice Department's like, we can't do that because we don't think it's legal, it's hard to say that action is somehow implicating the president in a criminal sense. That's a very odd thing. I mean, President Nixon somewhat famously had that's Massacre Sunday, when he fired the Attorney General, Deputy Attorney General, and Assistant Attorney General on the same day because they wouldn't do what he wanted to. But that doesn't expose you to criminal liability.
I think it super depends on what you're asking in particular. I don't know how narrow they're being. I imagine they're being exactly precise with the case. But what Donald Trump was accused of doing in the indictment for the Jack Smith federal case was asking his DOJ to tell a lie. He was asking his DOJ to fraudulently misrepresent the evidence they'd found for voter fraud in order to create a notice that he could send out to the 7 states that he wanted to overturn their elector votes to. I don't think any reasonable person would think that that's a president acting in the capacity as president for presidential policy. It was very clearly a personal, private ask that he was demanding of his DOJ that wasn't serving in any good capacity. If indeed that was a fraudulent request, which I mean is what the indictment is charging. Hold on, I gotta run. I'll be right back. Give me like 2 minutes, 1 second.
Okay.
My stream can hear you, so don't say anything you don't want my stream to hear.
Okay.
Or you can chat with them. One sec.
How y'all doing out there? How y'all doing out there? For those of you who are curious, my name is Kurt. I have the channel Uncivil Law. I do legal analysis. I hope you like it. We're going to do an oral argument, react to this case a little bit later when they have the synced transcript with the audio. Oye does a synced transcript that makes it a little bit easier to follow, so we'll cover it again later. Should be fun. We do Supreme Court analysis, Court of Appeal stuff. Good stuff. So if you like legal analysis, you can check that out. I'm also working on my own Supreme Court petition right now for a cert petition. It's my first one I've ever tried to write myself. So I'm pretty excited about that. I can't really talk about it in great detail because obviously it's still in the stages of being filed. But I'm representing a veteran who was arguably discriminated against in the workplace. And so she has lost at all the levels of appeal below. And so I am writing her Supreme Court cert petition as we speak. So that's exciting for me. And so if the Supreme Court grants my request, then I guess one day I'll be arguing in D.C., and that will be fun. How do I fancy Trump's chances in court? I think that he's likely to get relief in his favor. The degree to which he's going to get relief in his favor is questionable, but I think he's going to come up with some kind of a win from the Supreme Court. I think that Destiny was probably right, though, when he was suggesting that they will kick the can down the road. I think that's a pretty likely result. What are the odds that it happens, that the Supreme Court grants review of my case? About 1 out of 160, 1 out of 170, give or take. The Supreme Court grants something like 0.6% of requests. So, yeah, about 1 out of 160 chance of the Supreme Court saying yes, give or take. Although if they agree to hear my case, I think I have pretty good odds of winning on the merits. So that's good. What do I think of the Jan 6 defense? They didn't know the Capitol building was the Capitol when they protested. If you don't know the Capitol building is the Capitol, you are just too dumb. What did you think that big building with the dome on it exactly was? You're too stupid to have the protection of law at that point. If you want to argue you didn't know that Congress was having a joint session, then okay. If you don't know the big building with the dome on it is where Congress meets, I don't know what to tell you. That's just too much, man. I thought the dome was the Pentagon. The Pentagon does not have a dome. Also, the Pentagon is in Virginia, although it has a Washington, D.C. mailing address. There's a fun fact for the day. The Pentagon is also in the shape of a pentagon. That is a clue, yes. Do I like or dislike sporks? I'm not the hugest fan.
All right, sorry.
No worries. We're good. We're having fun.
Good. Glad.
Check out On Civil Law. Like, comment, subscribe.
Are private. But for an incumbent
Like,
president
comment,
to then
subscribe.
use private end, and many of the co-conspirators alleged in the indictment are private. But for an incumbent president to then use his presidential powers to try to enhance the likelihood that it succeeds makes the crime, in our view, worse. So in the Department of Justice episode, this occurs very late in the election cycle after many other schemes had failed.
And that is what he's talking about.
The petitioner is alleged to have tried.
He wasn't acting in the capacity of like asking the DOJ just to do things, but it was that specifically they were fraudulent asks.
Yeah, but I mean, they also are his. I mean, they're the lawyers for the executive branch. So whether or not he knows that, I mean, didn't they say earlier as part of the argument that the president has all this wonderful legal counsel, and so he has all these wonderful lawyers, and so he says to them, "Hey, can you do this?" And they're like, "No, we can't. That's fraudulent." It's like, oh, okay, well, thanks for the legal advice. I mean, wasn't that part of their rationale about why the president should be prosecuted earlier?
But that's not what happened. If the president would have said, hey, can we do something illegal? And they would have said no, then that would have been the end of it. But the problem was the president was saying, hey, I want you to do something that we all know is not legal. And then when they refused, I think it was when Rosen and Donahue refused, Trump sent Clark over and said, listen, if you guys don't do this, I'm going to just fire both of you. And Clark is going to be my new acting attorney general. And I think like half the White House staff or half of his like inner circle threatened to quit if that would have happened. And it eventually ended up not happening. So I think it was significantly different than just him asking his legal Justice Department a question. It was more him saying, I want you to do something that we all know here is illegal. And if you don't do it, I'm going to start firing you guys until I find somebody who will, which I think is substantively different.
Okay, fair enough.
I'm going to start firing you guys until I find somebody who will, which I think is substantively different.
Okay, fair enough.
None of this was true. The Department of Justice officials all said this is not true. We are not going to do that. And at that point, petitioner is alleged to have threatened to remove the Department of Justice officials who were standing by their oath and replace them with another person who would carry it out. We're not seeking to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. No, what we're seeking to impose criminal liability for is a conspiracy to use fraud to subvert the election, one means of which was to try to get the Justice Department to be complicit in this. The case would have been no different if petitioner were successful and he had actually exercised the appointment and removal power and it had gone through and those fraudulent letters were sent. It would have made the scheme more dangerous, but it would not have changed the crime.
And how do we think about things like conversations with the vice president? In other words, things that if you say it that way, it's clear that they would fall under executive privilege, but how does that relate to the question that we're asking here?
So this is one of the most difficult questions for the Department of Justice, and I want to explain why that is. If we are operating under a Fitzgerald versus Nixon lens and looking at this the way that we look at things when there is a private lawsuit filed against the president, we take a very broad view of what the outer perimeter of official presidential action is in order to be as protective of the president against private lawsuits that, as this court explained in Nixon versus Fitzgerald, can be very deleterious to the president's conduct of business. So if we were putting this under a Fitzgerald lens, we would then have to answer the question, was he acting in the capacity as office seeker or was he acting in the capacity as office holder? And if you run through the indictment, you can find support for those two characterizations, and the Department of Justice has not yet had to come to grips with how we would analyze that set of interactions.
Thank you.
Justice Gorsuch? If you did, though, I just wanted to confirm, I thought I heard you thought that the blazing game framework was the appropriate one. Is that right?
Largely, yes, Justice Gorsuch. We agree with the idea of the distinction between office holder and office seeker. We also agree that if it's objectively reasonable to view the activities as those of office holder, then the Fitzgerald immunity kicks in. I think we would look more at the content of the actual interaction in order to make that determination than Blasingame suggested, at least on the facts of that case, might be appropriate.
Can you give me an example of what you have in mind? I'm just trying to understand what nuance you're suggesting.
So Blasingame adopted a generally very favorable pro-government framework that we endorse in private civil cases.
Yeah.
Okay, not here, because we don't think that Fitzgerald applies in the criminal context.
I understand that,
okay.
but putting that aside, the distinction between official act and private office seeker,
yes.
Their test is, you think, good enough for government work?
On this one, the department hasn't taken a next step since the Blasingame decision, but let me offer a few thoughts that Justice Gorsuch I think might clarify it. The Blasingame decision focused on objective contextual indications to try to see whether the president was acting as a campaigner as opposed to an office holder.
Yeah.
I think that decision can also be made by looking at what the president actually said. And let me illustrate that with an allegation that I think my friend talked briefly. In one of the interactions between petitioner and a state official, petitioner is alleged to have said, all I needed you to do is to find me 11,000 if you look at that content, it's pretty clear that petitioner is acting in the capacity as office seeker, not as president. And we would look at that content.
Okay. But the test, I'm just focused on the legal test.
Correct.
I'm not hearing any objections to it.
Other than I think that the D.C. Circuit placed more content consideration off limits than I would.
Okay. All right. And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably. Do we look at the motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected as such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in reelection.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers.
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of
That's
motive.
right.
Okay.
That's right.
All right, so then we're in the non-core powers
Right.
where we're fighting over. What role do motives play there? I mean, one could remove an appointee that, well, first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court in cases like Myers and Seal of Law has regarded as having a constitutional status of being removable at will from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And
let's put that aside. Yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes, to enrich yourself, for example.
Well, bribery, all right,
Yes.
but that's what I was wondering. Do motives come into the core power analysis or not? And now I'm hearing, I thought I heard no, and now I'm hearing maybe.
I think maybe might be a little bit more appropriate because it's not involved in this case. The department has not had to take a position on exactly how these core powers would be resolved under an as-applied constitutional analysis. None is involved in this case.
And I guess I'm wondering, and I'm not concerned about this case so much as future ones too, but these non-core powers and maybe core powers where a president is acting with, at least in part, a personal interest in getting reelected. Everything he does, he wants to get reelected. And if you're allowing in motive to color that, I'm wondering how much is left of either the core or non-core powers.
So I would be fine with carving that out and deeming that to be something that's intrinsic in our electoral system. We're not talking about applying criminal law to somebody who makes an announcement that this program will be good for the United States, and somebody could come along and say, well, you really did it to get reelected. Leaving aside whether any of that violates a criminal law, I know that the next question is assume that it does. I'm doubtful that it in fact does, because I don't think criminal laws generally operate on motives as opposed to objectives and purposes. But
well, all right, intentions. I mean, if you frame a motive as an intention and intentions as a motive, as you well know, every day of the week. So let's put that aside.
I understand. We're putting that aside, that really to me falls in a very different category, and it is also possible.
So there's some motives or intents that are cognizable and others that aren't. I mean, it's awkward, right? When we look back at like the injunction, back to Marbury in the early cases, you can't enjoin a president.
Yeah.
Also meant you can hold him in contempt, right?
A sitting president.
For sure.
Justice Gorsuch, can I try one more time?
Well, let me just spin this out just a second, right? And it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, Nixon versus Fitzgerald. That's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's reelection or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other limits, reactions, thoughts.
Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I don't normally say, which is that's really not involved
Everything
in this case.
in
We don't have bad political motive in that sense.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the ages.
Yes, and I think I would start by looking at the statutes and seeing what restrictions they do place on the president's conduct. And for example, the statute that prohibits fraud to defeat the lawful functions of the United States, the statute defines what the purpose is that the defendant has to have in mind. It has to be to defeat something that the United States is doing, and it has to be by deception. I don't think that gets us into the realm of motive hunting in the area where we are as concerned, I think, as the court would be about doing something that would undermine the presidency and the executive branch.
Does it seem weird to be primarily focused on future rulings? Shouldn't we be focused on Trump's case primarily?
Oh, no. Not the Supreme Court.
No.
The Supreme Court's always got to think about what happens next. And it's a good thing for lawyers generally and our system of law. We have a common law system, which means that we build on top of the decisions of what happened before. And you can see that influence in any number of decisions. So you've got to be thinking in the long term about how these decisions will impact people in cases far beyond what's going on. If for no other reason, then you don't want to have a Trump rule. You want to have, if we're going to have a rule of law, we need to have a rule of law that just so happens to apply to Trump, but also applies to any number of other people. You don't want to have a Trump exception. So you got to think about the broader set of cases.
Yeah. And then also, like, the Supreme Court, this is the highest body in determining whether or not something complies or comports with the United States Constitution. So the Supreme Court has the final answer. So whatever they say becomes the legal precedent until a future Supreme Court changes their mind, or until an amendment is passed in Congress to essentially change the Constitution. So usually when you're making these rulings on these cases, the future precedent or the precedent you're setting for future cases is like arguably the most important thing you're considering, unless it's a very, very, very narrow ruling, basically. But obviously, this ruling and criminal immunity for future presidents and everything, this is a monumental, a huge decision that the court is tasked with taking up. So yeah, you absolutely need to be concerned with how this is going to impact everybody in the future. Decision that the court is tasked with taking up. So yeah, you absolutely need to be concerned with how this is going to impact everybody in the future.
A consciousness of wrongdoing and elevates that to consciousness of illegality, then we're in a different realm. Wanting to get reelected is not an illegal motive, and you don't have to worry about prosecuting presidents for that.
Yeah. Okay. Thank you, Mr. Creed.
Justice Kavanaugh?
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution, as the questions of the court.
So it's the Solicitor General?
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. I'm very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. I think that was a terrible decision for the presidency and for the country, and not because there were bad people who were independent. Reagan's administration, President Bush's administration, President Clinton's administration were really hampered, in their view, all three, by the independent counsel structure. And what I'm worried about here is that was kind of, let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president, usually was how it worked. And Justice Scalia wrote that the fairness of a process must be judged on the basis of what it permits to happen, not what it produces in a particular case. You've emphasized many times regularity of the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by the statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? To be sure, the investigation must relate to the area of criminal offense specified by the statute, but that has often been, and nothing prevents it from being very broad. I paraphrased at the end because it was referring to the judges.
Yes.
That's the concern going forward, is that the system will, when former presidents are subject to prosecution, and the history of Morrison versus Olson tells us it's not going to stop. It's going to cycle back and be used against the current president or the next president and the next president and the next president after that. All that, I want you to try to allay that concern. Why is this not Morrison v. Olson redux if we agree with you?
Well, first of all, the independent counsel regime did have many structural features that emphasized independence at the expense of accountability. We don't have that regime now, but even under that regime, Justice Kavanaugh, I think if you look at Lawrence Walsh's report on Iran-Contra, I think this goes to a very fundamental point for the court to consider. Judge Walsh said, I investigated these matters. The proof did not nearly come close to establishing criminal violations. So we've lived from Watergate through the present, through the independent counsel era with all of its flaws, without these prosecutions having gone off on a runaway train.
Well, I think President Reagan, President Bush, and President Clinton, whether rightly or wrongly, thought contrary to what you just said.
I think nobody likes being investigated for a crime, but it didn't result in the kind of vindictive prosecutions that I think Your Honor is raising as a possibility.
Yeah.
We have a different system now. I think there was a consensus throughout Washington that there were flaws in the independent counsel system. It lapsed. We now are inside the Justice Department with full accountability resting with the Attorney General. So the special counsel regulations now don't operate the way that the independent counsel regulations do. And this court would have something to say about it, I think, if the independent counsel statute were revived. I'm not sure that anybody is in favor of that.
Right. No, I was just saying this is kind of the mirror image of that is one way someone could perceive it. But I take your point about the different structural protections internally. And like Justice Scalia said, I do not mean to suggest anything of the sort in the present case. I'm not talking about the present case, so I'm talking about the future. Another point, you said, talked about the criminal statutes. It's very easy to characterize presidential actions as false or misleading under vague statutes. So President Lyndon Johnson, statements about the Vietnam War. Say something's false. Turns out to be false that he says about the Vietnam War. 371 prosecution after he leaves office?
I think not, but this is an area that I do think that merits some serious and nuanced consideration. Statements that are made by a president to the public are not really coming within the realm of criminal statutes. They've never been prosecuted. I realize that the court can say, well, what if they were? And then I think you get to what I would regard as a hard constitutional question that would probably guide the court away from trying to resolve today, although I do think it's very different from our case and distinguishable in important ways. But you're dealing here with two branches of government that have a paramount interest in the integrity and freedom of their interactions with each other. On the one hand, the president, of course, should be very free to send usually his cabinet officials and sub-cabinet officials to testify to Congress to provide them with the information needed to enact legislation and to make national policy. And we're very concerned about anything that would trammel that. On the other side of the equation, Congress has a compelling interest in receiving accurate information, and at the very least, not information that is intentionally and knowingly false. Right. That would pollute the legislative process.
I think it came up before, President Ford's pardon. Very controversial in the moment.
Yes.
Hugely unpopular, probably why he lost in '76.
Yes.
Now looked upon as one of the better decisions in presidential history, I think, by most people. If he's thinking about, well, if I grant this pardon to Richard Nixon, could I be investigated myself for obstruction of justice on the theory that I'm interfering with the investigation of Richard Nixon?
So this would fall into that small core area that I mentioned to Justice Kagan and Justice Gorsuch of presidential responsibilities that Congress cannot regulate.
How about President Obama's drone strikes?
So the Office of Legal Counsel looked at this very carefully and determined that, number one, the federal murder statute does apply to the executive branch. The president wasn't personally carrying out the strike, but the aiding and abetting laws are broad. And it determined that a public authority exception that's built into statutes and that applied particularly to the murder statute because it talks about unlawful killing did not apply to the drone strike. So this is actually the way that the system should function. The Department of Justice takes criminal law very seriously. It runs it through the analysis very carefully with established principles. It documents them, it explains them, and then the president can go forward in accordance with it. And there's no risk of prosecution for that course of activity.
Thank you for your answers.
Justice Barrett?
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the model penal code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blasingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me. Do you agree or disagree?
You know, Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolicking detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive acts to me. There is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority
Destiny, I'm trying to figure out why they apply this post hoc charging as setting a bad precedent when being impeached is a thing a president has on their mind when practicing their discretion, or what? Do you have a response? The difference is that the getting an entire impeachment through is a far more rigorous process, arguably, than even a criminal conviction. So the chances of being impeached and then convicted in the Senate are lower than probably even a criminal conviction or criminal court. And two, the worst thing that can happen to you as a result of a Senate impeachment Senate conviction after an impeachment is that you're removed from office and you can't hold a future office. Arguably, these are less penalties than what you could face in criminal court. So a president should be worried about being impeached. Everybody should be worried about removal from office in a democracy, because if you're not performing your duties well, then we can remove you from office as a democracy. It's part of what we do here. But there's a fundamental difference between removal from office via an impeachment versus criminal liabilities, which involve almost definitionally deprivation of your freedoms guaranteed to you in the United States. There's a difference.
Yeah. And you want a public official to be worried about being impeached because that's like part of their job. You don't necessarily want them to be worried about like criminal things for doing their ordinary duties, basically. Sorry, go ahead. Yeah, and as Destiny sort of alluded to, the threshold to get convicted is so high. With 2/3 vote, you need a lot of your own party to vote against you. With the president, that's going to be unlikely, and except in the most dire of circumstances. I mean, even in when they were kicking George, what Soros is his name, out of the House? The House guy who got kicked out?
Santos or whatever?
Santos, apologize, not Soros, Santos, I apologize. George Santos, when they were kicking him out of the House, it took like 3 times to get him kicked out of the House because of how much of a political blow that was to get members of his own party to vote against him. And then when you're talking about the president, the political ramifications of that are even so much more obvious. So whereas opposed to getting indicted, you just need a prosecutor and you need a grand jury, which is fairly easy, and you just need to find some sort of criminal exposure. And the U.S. government long ago gave up trying to even count how many federal criminal laws there are, because when you count all the laws and all the regulations and all the incorporations, it becomes a nest. So you can just sit down and find someone who is something that you did. And also just a friendly, I appreciate the chat that's here and is so nice to, it's been so nice to me. I appreciate them. They're very, very kind to me. So thank you.
Nice. Okay.
I appreciate the chat that's here and is so nice to, it's been so nice to me. I appreciate them. They're very, very kind to me. So thank you.
Nice. Okay.
When the president takes such actions that, the court's been asking you, might this result in criminal prosecution? You say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function?
And therefore, I acted lawfully.
Therefore, I acted lawfully and
Yes.
I'm not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking you. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then an interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get out of jail free card.
Yes, I understand that, and I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 Generally, in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory appeal with review of facts before you could ever get it forward into a criminal case. That said, if I would prefer a regime in which the court altered some of the procedural rules surrounding the president than a total, absolute blanket immunity that takes away the possibility of criminal prosecution, even if it was a core violation of the statute in the teeth of Attorney General advice and has no overriding public purpose.
You think it has to be a jury question? And I mean, let's see, I wasn't necessarily proposing actually treating it as a defense that was done at the outset and then subject to interlocutory appeal. I was proposing, what about an immunity doctrine that drew from the public authority defense that the Department of Justice thinks would otherwise apply? So just go with me on that for a minute. Why would it be so bad for it not to be a jury question? I mean, it seems to me that some of these Article 2 concerns would be exacerbated by having it go to a jury rather than a judge.
So I think some of them are judge questions that could be resolved on the face of the indictment. If the Department of Justice ever returned an indictment that said the issuance of this pardon or this series of pardons constituted obstruction of justice, I have a little difficulty hypothesizing it, but a motion could be made on the face of the indictment that says Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a...
When we say interlocutory appeal, are we talking about like dismissing a charge as like a pretrial matter? Is that what we're essentially talking about?
All interlocutory means is that the appeal is ongoing while the trial is still ongoing. So we're appealing something before the trial is concluded. Some sort of order, some sort of ruling For example, like an immunity, like this issue would be an example. This is all on interlocutory appeal because obviously the trial hasn't concluded yet. Trump has neither been convicted nor acquitted. It's an interlocutory appeal because if he does have immunity, then the trial should never happen. And obviously you can't fix that after the trial's over because the trial's happened. So you have to hear it. You have to hear it now. So interlocutory just means that you're in the middle of trial. That's all it means.
Gotcha.
Yeah.
Okay. Okay.
Yeah.
Offenses, though, really do intersect with the general issue. And for those, I have a much greater time seeing how the court could implement that. And would there be costs in going to trial? Yes. There is no perfect system here. We are trying to design a system that preserves the effective functioning of the presidency and the accountability of a former president under the rule of law. And the perfect system that calibrates all of those values probably has not been devised. I think that the system that we have works pretty well. Maybe it needs a few ancillary rules. It is different from the radical proposal of my friend.
I agree. Let me ask you about state prosecutions, because if the president has some kind of immunity that's implicit in Article 2, then that immunity would protect him from state prosecutions as well. A lot of the protections that you're talking about are internal protections that the federal government has, protections in the Department of Justice, which obviously are not applicable at the many state and local jurisdictions across the country. What do you have to say to that?
So that raises a Supremacy Clause issue, and the court would run a Supremacy Clause analysis that would probably start with basic principles like McCulloch versus Maryland. The states do not have the authority to burden federal functions, and would then kind of move through in Nagel, where the court said that a state murder prosecution of a federal official guarding a Supreme Court justice and who fired a shot was not permissible. If the court thought that you needed a more categorical rule for the states, I think the Supremacy Clause certainly leaves it within the court's prerogative to determine that the president, unlike all other officials, deserves more of a robust federal defense than what I have just described.
But it would still be a defense in the states. It wouldn't be, I mean, well, that's my point. Like, it's one thing to say, well, the president, they're not going to be these prosecutions that are politically motivated, the things that Justice Kavanaugh was referring to that might be the danger of the system, one thing that we have to worry about. That might not carry the day, but, that's a concern. It's totally different when you take it outside of the Department of Justice and its structures, and then you throw it out elsewhere. The idea across the states, the idea of an immunity,
Amy's questions here are very good.
If you're talking about
and in uncivil law, I think earlier kind of hinted to this, that for Dreeben, a lot of the arguments that that Dreeben is bringing up is saying that, like, okay, well, listen, sure, there are ways that we could conceive of this being abused, but like they brought up how the independent counsel used to work in the past, and how a lot of that is in-house under the DOJ now, and how there's a lot of, like, inside the DOJ, there's a lot of oversight from the Attorney General, and look at these wonderful systems of checks and balances, even theoretically built into the DOJ and federal prosecution that would prevent these things from happening. And then Amy's saying, like, okay, sure, let's assume that all of that is true. So we're not going to grant immunity because in the DOJ, you guys can protect against this. But what about the fact that we have 50 different state courts that might find some nexus between some violation of rights or whatever? Now, all of these courts could theoretically hold former president to stand trial for criminal charges. And they don't have all of these same protections that you're talking about that might be built into the DOJ. Well, what's your answer to protect from, I don't know, would you call it frivolous criminal lawsuits or politically motivated criminal lawsuits in all of these independent states?
Yeah, I mean, that's a real problem because the president is doing actions everywhere. And so every single county has a prosecutor, and there's a lot of people with potential motivation to make a name for themselves as long as they can find some kind of jurisdictional nexus. So they try to say, well, look, the Supremacy Clause, the federal law is supreme and the states can't interfere with the federal function. I'm like, yes, that's true as far as it goes, but you're the ones, DOJ, right now, who are trying to say that the president doesn't have absolute immunity from the criminal law. And so if there's a state law that somehow, at least theoretically, it could be the case that the president's doing something for which there might be some state exposure, for which the Supremacy Clause analysis would suggest otherwise. And so now potentially you have state prosecution. So what are you going to do about that? And as I said, I was really disappointed in the DOJ's brief because they dismissed this literally in a sentence in a footnote. I was like, that is just like, that's felt so thin.
All right. Resume.
Like, that is just like, that's felt so thin.
All right. Resuming.
Purchase, if you're talking about something that protects the former president from standing trial and the state and local level.
So I don't know that you would have to design a system in which the president would have to stand trial at the state and local level. It's certainly within the court's authority as a matter of Supremacy Clause law to find an immunity. But we have been talking here about, at some length, on the distinction between official acts and private acts.
Yeah.
That will have to be determined by some sort of a process. Any immunity defense that the court announces can still be met by a state assertion that we're prosecuting private conduct. You're going to have some process. I think having some legal process is not a reason to cast aside a nuanced system that actually looks at what protections are necessary as opposed to what would provide the absolute maximum insulation for former presidents, even if we acknowledge that it's highly prophylactic.
Totally agree, and I wasn't actually contrasting the absolute immunity rule. I was saying that if there was some sort of official private, there are consequences towards about making immunity. Okay, and since you bring up the private acts, this is my last question. So I had asked Mr. Sauer about on page 46 and 47 of your brief.
Yes.
You say even if the court were inclined to recognize some immunity for a former president's official acts, it should remand for trial because the indictment alleges substantial private conduct.
Yes.
And you said that the private conduct would be sufficient.
Yes.
The special counsel has expressed some concern for speed and wanting to move forward. So, the normal process, what Mr. Sauer asked, would be for us to remand if we decided that there was some official acts immunity and to let that be sorted out below. It is another option for the special counsel to just proceed based on the private conduct and drop the official conduct?
Well, two things on that, Justice Breyer. First of all, there's really an integrated conspiracy here that had different components, as alleged in the indictment. Working with private lawyers to achieve the goals of the fraud, and as I said before, the petitioner reaching for his official powers to try to make the conspiracies more likely to succeed. We would like to present that as an integrated picture to the jury so that it sees the sequence and the gravity of the conduct and why each step occurred. That said, if the court were to say that the fraudulent elector scheme is private, reaching out to state officials as a candidate is private, trying to exploit the violence after January 6th by calling senators and saying, please delay the certification proceeding is private campaign activity. I still think, contrary to what my friend said, that we could introduce the interactions with the Justice Department, the efforts to pressure the vice president, for their evidentiary value as showing the defendant's knowledge and intent, and we would take a jury instruction that would say, you may not impose criminal culpability for the actions that he took. However, you may consider it insofar as it bears on knowledge and intent. That's the usual rule with protected speech, for example, under Wisconsin versus Mitchell. My friend analogizes this to the speech or debate clause, but we don't think the speech or debate clause has any applicability here. It's a very explicit constitutional protection that says senators and representatives shall not be questioned in any other place. So it carries an evidentiary component that's above and beyond whatever official act immunity he is seeking. And the last thing I would say on this is we think that the concerns about the use of evidence of presidential conduct that might otherwise be official and subject to executive privilege is already taken care of by United States versus Nixon. That balances the president's interest in confidentiality against the need of the judicial system for all available facts to get to the truth. And once that has been overcome, we submit that evidence can be used even if culpability can't rest on it.
I thought these were decent answers. So just to summarize these, like people are saying like, or Amy's asking like, well, aren't we running the risk of criminalizing like a ton of behavior that we don't want to criminalize? And I guess the response is basically that, well, there can be things that we want people to have immunity from criminal liability for, but these can still be considered in a courtroom as evidence towards intent for something else. So maybe theoretically, I'm just going to use hypotheticals. I don't know what the actual laws are, but like hypothetically, let's say we have a law saying that a senator can never be convicted for a speech that he gives from his own lawn. Okay, you can never convict him for that speech. Mm-hmm. So he can go on his front lawn and he can say something like, "Oh, tomorrow, I am with full knowledge and malintent, I'm going to kill my political rival." And then let's say the next day there's a car accident that happens and he kills his political rival. The argument would be, okay, well, you cannot convict him for the speech that he gave on his lawn. However, the jury should be allowed to consider the conduct on his lawn, not to hold him criminally liable for what he said, but to use that speech to inform the intention of the other act, is essentially what's being said here. So we were saying that there are certain acts that the president, that Trump here in this case, maybe he wouldn't necessarily, or other officers of the court or other elected members of court, of Congress, you wouldn't hold them criminally liable for them, but we should still be allowed to put this type of behavior in front of a jury and have them consider it as an intentional part of another behavior. Because the January 6th indictment from Jack Smith here incorporates a lot of different things that Donald Trump did and statements that he made, maybe some even in his official capacity, maybe you wouldn't hold him culpable for these, but they go to illustrate, like his conversations with Pence was brought up, the intention that he had behind the other actions that they do want to hold him criminally liable for.
Yeah, I mean, you can analogize it other ways too, like just speech that is protected but informs, your intent or lack of ignorance of a defense. That you say, well, I didn't know that, I was doing XYZ, but you had earlier said something that indicates that you did know that. So you're using the purely lawful speech. It's like, I can't go to the restaurant. It's closed at 9 p.m. And then, forward later, it's 11 p.m. and suddenly you're in the restaurant. It's like, I didn't know they closed. I just thought they were open. I wasn't committing burglary. So you're using the earlier speech to prove the absence of mistake. Mm-hmm. So that kind of thing. The earlier speech to prove the absence of mistake.
Mm-hmm. Yeah.
So that kind of thing.
we submit that evidence can be used even if culpability can't rest on it.
Thank you.
Justice Jackson?
Just to pick up where Justice Barrett left off, I think I heard you say that even if we decide here something, a rule that's not the rule that you prefer, that is somehow separating out private from official acts and saying that that should apply here, there's sufficient allegations in the indictment, in the government's view, that fall into the private acts bucket that the case should be allowed to proceed.
Correct.
Because in an ordinary case, it wouldn't be stopped just because some of the acts are allegedly immunized, even if people agree that some are immunized. If there are other acts that aren't, the case would go forward.
That is right.
All right. Going back to the clear statement argument, I'm struggling with that argument because my understanding was that when a charged criminal statute is read narrowly in the presidential context to not apply to the president, a constitutional question is being avoided. So you're doing that to avoid having to deal with the constitutional question. So what is the constitutional question that is being avoided in those kinds of situations?
A serious one. This is just an application of this court's ordinary construction of criminal statutes, that if there is an available interpretation that would avoid a serious constitutional question, the court's preference is to...
Right, and the nature, I guess I'm going at, my understanding is that what is being avoided in that situation is the question of whether a former president can be held criminally liable for doing the alleged act that is being asserted in that statute consistent with the Constitution. So we look at the statute, it's got some elements in it, and we are saying, well, geez, if this statute and those elements apply to the president's conduct in this situation, we'd have to answer the question, can the president be held liable consistent with the Constitution for that behavior? Is that right?
So the first step in that analysis, I just want to... Yes, but the first step is there ambiguity? And these statutes apply to any person, they apply to whoever. There's no ambiguity in those phrases. This court in Nardone versus United States concluded that similar words, any person, apply to government officials.
All right, well, let's just assume that I guess I'm just trying to get at, we're avoiding a constitutional question if we do that in the ordinary case. And what's confusing to me about this case is that we're not being asked to avoid the constitutional question. In fact, the question of whether or not the president can be held liable consistent with the Constitution or does he have immunity is the question that's being presented to us. So I don't understand how the clear statement kind of analysis even works. It seems completely tautological to me for us to hold that presidents cannot be prosecuted under any criminal statute without a clear statement from Congress to avoid the question of whether or not the Constitution allows them to be prosecuted. We'd have to have a reason, right? I mean, we'd have to have a rationale for applying the clear statement rule.
I think the court would have to have some rationale that's not evident in
I don't understand her confusion.
And just one data point for the court in thinking about how the clear statement rule works in the United States.
Well, I don't know what the point of this question is. It sounds like she's saying that, like, generally we try to read statutes narrowly so that we're not having to ask a very difficult constitutional question. But in this case, we basically have to answer a really difficult question. I don't know why she's asking it. Like, obviously that is what's before the court.
Yeah,
so
because I mean, this idea of this clear statement rule is we're going to assume the statute doesn't apply to the president unless Congress makes it clear that they want to apply to the president. And the reason that we're going to make that assumption is because if we assume it doesn't apply to the president, then we don't have the problem of potentially Congress interfering with the executive branch. We don't have the inter-branch conflict. So we're going to interpret every statute as not applying to the president because that helps us avoid the constitutional question. Now, in a hypothetical where Congress wrote, no, we want this to apply to the president. Well, in that hypothetical, now we can no longer avoid the conflict. Now we have to say, okay, Congress wants this to apply to the president. Can they do it? We have an unavoidable conflict. We have to answer the constitutional question. So I don't understand her point because it's like this, the clear statement rule is one way to avoid the conflict. It's like, all right, we can avoid the constitutional question about whether or not the president is immune by simply saying Congress didn't apply this to the president. It solves the conflict. You don't have to answer the constitutional question. You root it in statute. Congress didn't make it clear. We all go home without answering the constitutional questions. So I don't really understand her confusion.
If you do that, you kind of have answered the question, though, haven't you? Because now every single prior statute that doesn't make it clear essentially doesn't apply to the president, and in a way, we've kind of answered it, right?
Yeah, we've made it clear that every single statute, except the few that explicitly mention the president, don't apply to the president. So, yeah, that solves that problem. But we root it in Congress not being smart enough to put it in the statute, which, strictly speaking, makes it a statutory problem. So, I don't know. Yeah. I'm not sure I really like this idea personally. I don't think it's the right way to solve the problem. But it's a proposal, I guess. Right way to solve the problem, but it's a proposal, I guess.
Sure.
familiar with. Justice Scalia wrote an opinion for a unanimous court in which he used a hypothetical about what would happen if the president received a sports replica jersey at a typical White House event. Would that violate Section 201C? And the court offered a construction that it had to be for because an official act to avoid that problem. I think if there was such a well-received understanding that presidents are not included in general federal criminal law unless the president is specifically named, which he is not in Section 201, Justice Scalia would have thought of that, and some member of the court would have reacted, and none did.
All right, let me go on to ask about what you take the petitioner's position to be in this case, because we've had a lot of talk about drawing the lines. Justice Kavanaugh, Justice Gorsuch suggested that we should be thinking about Blassingame, and that within the first we have private versus official, and then within official now we have something about core acts versus other acts as we try to figure out, at what level the president is going to have immunity. The petitioner's argument in this case not to be inviting us to engage in that kind of analysis. I thought he was arguing that all official acts get immunity, and so I didn't understand us to be having to drill down on which official acts do. And so my question is, why isn't it enough for the purposes of this case, given what the petitioner has argued, to just answer the question of whether all official acts get immunity?
That is enough, and if the court answers that question the way that the government has submitted, that resolves the case. I want to make a clarification that I may have left the court with some uncertainty about. The official act analysis that my friend is talking about is the Fitzgerald versus Nixon outer perimeter test, which is extremely protective of the president. It's not looking at core versus ancillary. It's saying everything the president does is a target for private civil lawsuits. That's not a great thing, and therefore they are all cut off.
That's an absolute immunity kind of concept, right? Anything that's official
unless I'm
in the outer perimeter.
Misreading this or misunderstanding this, what they're talking about, that only applies to, I believe, civil matters, right? That doesn't shield you from criminal liability. It's just for private cases, right? Okay.
That is the precedent, sure. Yeah, they're trying to extend that out to the criminal law. But as I sort of pointed out, this idea of the absolute immunity applying to the criminal context has been the understanding of the laws it relates to prosecutors, for example, and judges, for example. And then you get into the idea of it not being within the scope of their official role. For example, bribes is not within the scope of their official role. But absolute immunity as a criminal immunity is not a novel concept. So, yeah, that's what they're talking about. Concept. So, yeah, that's what they're talking about.
The bucket of official. Now let's figure out which might be subject to liability, not on the theory of absolute immunity, correct?
And neither on the theory of absolute immunity or on our theory. On his theory, everything's protected. On our theory, there is no immunity. But this is where I would draw the distinction. There are as-applied constitutional challenges that you run through the Youngstown framework and this court's customary method of analysis, and you determine whether there's a infringement of Article 2.
So what you're saying is, even if we reject the absolute immunity theory, it's not as though the president is, doesn't have the opportunity to make the kinds of arguments that arise as at the level of, this particular act or this particular statute has a problem in retrospect. I think I hear you saying we should not be trying to, in the abstract, set up those boundaries ahead of time as a function of sort of blanket immunity, allow each allegation to be brought, and then we would decide in that context.
Yes, with the additional note that petitioner has never made that argument, and I think it would be up to a district court to decide whether to go that route at this point in the litigation. He's put all of his eggs in the absolute immunity basket.
All right, and if we invite, if we see the question presented as broader than that, and we do say let's engage in the core official versus not core and try to figure out the line, is this the right vehicle to hammer out that test? I mean, I'd understood that the most, if not all, but most of the allegations here, there's really no plausible argument that they would fall into core versus not, such that they are immune.
We don't think there are any core acts that have been alleged in the indictments that would be off limits as a matter of Article 2.
So if we were going to do this kind of analysis, try to figure out what the line is, we should probably wait for a vehicle that actually presents it in a way that allows us to test the different sides of the standard that we'd be creating, right?
I don't see any need in this case for the court to embark on that analysis.
All right, the final sort of set of questions that I have to do with what I do take as a very legitimate concern about prosecutorial abuse, about future presidents being targeted for things that they have done in office. I take that concern. I think it's a real thing. But I wonder whether some of it might also be mitigated by the fact that existing administrations have a self-interest in protecting the presidency, that they understand that if they go after the former guy, soon they're going to be the former guy, and they will have created precedent that will be problematic. So I wonder if you might comment on whether some of the caution from the Justice Department and the prosecutors and whatnot comes from an understanding that they will soon be former presidents as well.
I think absolutely, and I would locate this as a structural argument that's built into the Constitution itself. The executive branch, I think, as this court knows, has executive branch interests that it at times asserts in opposition to Congress so that the proper functioning of the president is protected. And I believe that that value would be operative and is operative in anything as momentous as charging a former president with a crime.
And I would also say, I think, and ask you to comment on, presidents are concerned about being investigated, evaded, and prosecuted, and it chills to some extent their, ability to do what they want in office. And that's a concern on one side. But can you comment on the concern about having a president unbounded while in office, a president who knows that he does not have to ultimately follow the law because there is really nothing more than, say, political accountability in terms of impeachment? I mean, we have amicus briefs here from Professor Liederman, for example, who says, a president would not be prohibited by statute from perjuring himself under oath about official matters, from corruptly altering, destroying, or concealing documents to prevent them from being used in an official proceeding, from suborning others to commit perjury, from bribing witnesses or public officials. And he goes on and on and on about the things that a president in office with the knowledge that they have no criminal accountability would do. I see that as a concern that is at least equal to the president being so worried about criminal prosecution that he, is a little bit limited in his ability to function. So can you talk about those competing concerns?
So, Justice Jackson, I think it would be a sea change to announce a sweeping rule of immunity that no president has had or has needed. I think we have also had a perfectly functioning system that has seen occasional episodes of presidential misconduct. The Nixon era is the paradigmatic one. The indictment in this case alleges another. For the most part, I believe that the legal regime and the constitutional regime that we have works, and to alter it poses more risks.
Thank you.
Thank you.
Thank you, counsel. Rebuttal, Mr. Sauer?
I have nothing further, Your Honor.
Wow.
Thank you, counsel. Counsel, the case is submitted.
That's a pretty big mic drop
Is now
there.
adjourned until Thursday, the 9th of May at 10
Oral
o'clock.
arguments for this case. People are saying, or the predictions, I don't 100% know why, but apparently they're just going to kick it back to the lower court and ask them to rule on something more specific rather than ruling broadly on this. But I guess I feel like Dreeben, I think, made obviously superior arguments to Trump's counsel. I think Sauer's position is entirely untenable. I think the broad criminal immunity is it would be a wild precedent. And I don't think the fears of infinite criminal prosecution, I don't think they're very well-founded fears, but yeah.
I did appreciate that mic drop right at the end, though. I have nothing further to say. So that's pretty good.
Yeah.
It's bold.
Yeah, well, any other final thoughts or...
No, I think, it just presents, it's a very interesting and complicated question because you want to on the one hand, make sure that the president, along with everyone else, is upholding the law. But I think that these concerns about the president being tied down or concerned about prosecutions from his political rivals is a strong concern. If for no other reason than it seems lately that, in each election, we are told that this is the most severe election and this is the worst president of our lifetime. And so the political incentives and doctrinal incentives for one government to go after the other is very large. And I think we've seen in other countries of the world, including in the modern era, how that can sometimes manifest with, every former president or person of equivalent station just being prosecuted by their new political rivals. And we don't want to run into that situation where it just seems endless and, just seems completely something that people are taking advantage of for political expediency. So I think the concerns on the other side are somewhat real.
I think that's a real concern, but I think that concern is dramatically overshadowed by the concern of a president having unlimited criminal shielding in his final days in office. I think that would be an unbelievable precedence that there's just absolutely no criminal liability for any action that a president does in office, assuming he's not going to get impeached. I think it would turn fundamentally the understanding of rule of law in this country, I think, on its head. I don't think any of the framers, deciding what a president is like, who's very much not a king, would have had that in mind. Yeah, I think the challenge is that you're dealing with an unprecedented ex-president who's taken relatively unprecedented actions. So any rule you craft here seems very scary. But I think that people underestimate the scariness on the other end as well, and how many different parts of the government had to hold to prevent Trump from essentially coupping the incoming regime. Yeah, and that's it's pretty spooky to me, but.
No, I definitely think there's legitimate concerns to be had, but the idea that some prosecutor, we've already heard the claims against Biden, and the degree to which you think those are important, I suppose, depends on your political predispositions, and the idea that we won't just end in an endless cycle of investigations and recriminations seems problematic. So
don't we already do that in Congress anyway, though? Like with the Hillary email thing, with the Jim Jordan impeachment thing, with the Russiagate thing, with the 9/11. Like we already have ways in Congress that this can continue, even absent criminal stuff.
Well, I think Congress is, if nothing, is a cautionary tale, because was pointed out as well in the briefs. We had one impeachment, Andrew Johnson. And then we've had, what, 4 different impeachments in the last 20 years or something like that? Possibly 5 if we count Biden's, which hasn't been formalized into an impeachment yet, but seems to be heading in that direction. And we are heading into this it seems like we're endlessly impeaching each other. And the endless investigations in Congress are a cautionary tale, because it's like once you open this door, it seems in our modern era, it just never stops. So I appreciate that's what's happened to Congress. I would just appreciate if it doesn't also happen to my judicial branch.
Yeah, I guess the question would be: do we feel like any of the do we feel like any of the recent impeachments were bad ones? Like, should Clinton have been impeached for lying under oath about Monica Lewinsky?
Well, I mean, I think it's a pure political question, because I think Congress can kind of do whatever it wants, because Congress is the sole judge of its own rules.
Well, but if somebody were to impeach somebody for having a small dick, I think we would both agree that it's probably not a good, regardless of our political leanings, right? I feel like the impeachment of President Clinton, I think, was fair. We can argue, I guess, over the impeachment of Donald Trump, but I think the two of them. But I guess the question here doesn't seem to be one of like procedure, which I think is what you're focused on, which I agree. I think it's more of like a political question, and I think it's representative of how divided we are as a country right now for how Americans are feeling about this. So I feel like in the American system, we're trying to solve like political differences in the country and the population through procedural remedies, which just can't happen. Like, whether we give the president immunity or not, whether we impeach or not, they're always going to find ways for our system to break and fuck itself if we are so unimaginably divided, factually in this country against each other, I think.
Yeah, you can't bad faith proof a system. And where I'm kind of curious is, I'm sorry, what's your name?
My name is Kurt.
Law, Joe?
My name is Kurt. How are you? What's your name?
I'm Josiah.
Hi, Josiah. How are you doing?
I'm doing well, man. So I'm kind of curious, though. So, like, my understanding is, and I think, I think the Solicitor General made a pretty compelling case here, that it was understood since the founding of the country, and I think Justice Jackson said this too, presidents seem to have operated under the impression that they could be criminally prosecuted after they leave office. And I know the Nixon and Ford example, to me, is the standout, because when Ford gave his statement as to why he pardoned Nixon, he made it pretty clear in the statement that he thought that Nixon could be prosecuted. That's why he issued a preemptive pardon, or not a preemptive pardon, but to preempt the prosecution. So you're worried that if they don't grant blanket immunity, that there's going to be a tit for tat here. But we haven't seen that in 230 years. We haven't even seen that since Nixon, right? So why are you so convinced that that would change here, number one? And number two, the comparison with impeachment, I actually think you kind of refuted it yourself when you acknowledged that impeachment is an inherently political exercise. So there's no real burden of proof. You just need a simple majority in the House, and you need 2/3 majority in the Senate, right? You don't actually, it's not like beyond all reasonable doubt or anything like that. It's not a criminal case. So can you kind of elaborate as to what your fears are about this? And actually, and the last thing I'll say is, other democracies across the planet, Japan, France, South Korea, they have prosecuted former heads of state, and they're still functioning.
Yeah, I mean, South Korea, I'm not sure how good an example is that, because it seems like every president winds up getting prosecuted in South Korea. But my concern is that the lawfare concern that, no one's tried to criminally prosecute a president before, and you can say they were on the way to Nixon, but obviously that didn't happen, and now we are prosecuting this president, and it just, I'm just concerned about the precedent, because it seems like the warnings about how this will happen next sometimes get ignored. I remember when Mitch McConnell warned Harry Reid, for example, on the floor of the Senate, when they broke the filibuster for the federal judges, how they'd rue the day. And it was only a couple of years later that, they broke it again for the Supreme Court justices using the same logic. So it seems like whenever one party breaks a certain Rubicon, it seems like it's fair game for everybody. And then it's, turtles all the way down. And so I'm just concerned about that.
Well, it's interesting that you cite the Reid example, because doing a filibuster carve-out for executive and legislative appointments, executive and judicial appointments, which is what happened with Reid and McConnell. There again, number one, that was a political exercise. Number two, Reid repeatedly warned McConnell, because at the time McConnell was cock-blocking Obama's appointees to an unprecedented extent.
This is true.
Literally half of all filibusters and Senate blockages of presidential appointees, half up until that point, happened under Obama's administration, because remember, McConnell famously said, we're going to make him a one-term president. We are going to obstruct every step of the way. And Reed's position was, listen, yeah, advise and consent, but you don't have the right to just literally blanket no, 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 no to every presidential appointment. If you keep doing it, if you keep acting in bad faith, obstructing, we'll change the rules. So to me,
well, I'm not sure why you don't. I mean, consent also means not consent. I can just say no because I don't want to.
Right, but if the shoe was on the other foot, how would Republicans have responded?
Well,
exactly the way Democrats did, right? Exactly, and we actually kind of saw that in a way. We actually saw that in an aggressive, unprompted way from Republicans when Donald Trump won the presidency in 2017, and Republicans took the majority. They removed the blue slip veto from circuit court judges just preemptively to prevent Democrats from vetoing Trump's judicial appointments for circuit courts in those states. So my point is, it kind of goes back to, I don't know if it's Kagan or Sotomayor, who were like, you can't bad faith proof a system. And I take your point that, again, there may be a tit for tat. Obviously, there's room for a tit for tat if this happens. But what's the alternative? That I think Justice Jackson says, the president's already the most powerful person in the world at the time that they're in office. You want to open the floodgates and make that, that power even more unchecked? To me, that's the greater risk. And I don't think, with respect, I don't think that you're seriously grappling with that.
I don't think that's fair that I'm not seriously grappling with it. I have concerns on both ends. I think there's, as I've sort of been trying to work through it myself, I think there's a lot of concern about doing it, and there's a lot of concern about not doing it for largely the same reasons. You don't want to have an unchecked person who can just do whatever the hell they want with no check. And perhaps, to use the DC Circuit's example, they're committing SEAL Team 6 to perform political assassinations, and maybe members of Congress don't want to impeach because they're concerned about them being next and all the rest of it. So you don't want to live in that world. And I'm also concerned about the exact opposite of that with the DOJ's position of just complete exposure to all the criminal law. Because as I said, there's so many laws on the books that even the federal government can't keep count. There was a good book written by a law professor, said 3 felonies a day, which basically argues the average citizen commits 3 felonies a day because of just how many laws there are on the books. And I'm just concerned that the motivation.
Wait a second, wait. What's the source for that? What do we mean when we say that?
Silverstein or Silverstein, I want to say, wrote that.
I'm sorry, I didn't mean I just mean what 3 felonies a day? There's a mens rea component to most criminal matters. What is an example felony somebody might commit without even having awareness of it?
I mean, I don't know off the top of my head, but the idea is just there's so much exposure that if you just try to if you really put your mind to it, you can probably find something.
I feel like there's a lot of exposure to civil stuff for sure, but criminal stuff, or maybe citation stuff. I don't know. Do you consider speeding tickets aren't criminal matters, right? Isn't it considered something different?
Typically, no, they're not considered criminal.
Yeah, so I mean, but exposures to every citizen is committing felonies. That I find that hard to believe insofar as criminal law goes. That so many people have so much potential criminal liability they're totally unaware of.
Yeah, it was Harvey Silverglate. I was pretty close on that. So if you want to look up his idea on that, you can check that out for yourself at some time. It's been a long time since I read it, but that it's just there's just so much exposure. So.
I was looking here at the DC Circuit Court's decision, which preceded this one, and I'm pretty sure there's a passage. And I'm not an attorney, you are. Aren't there laws or protections against fishing expeditions or frivolous lawsuits or things like that? I'm pretty sure it's referenced in the DC decision on this, that's a protection that would be available to Donald Trump or any ex-president if kind of what you fear comes to pass, which is that the next administration from the opposition party would pursue legal actions against their predecessor. Aren't there laws that protect against frivolous lawsuits or things like that?
Sure, there is, but if you can come up with an exposure that makes the prima facie standard, you can get investigation. So as a private individual, sure, because it's harder for a private individual, but the government with their resources and warrants and other things, I mean, it's definitely a problem.
Okay. So the other thing I was going to ask you about, because I don't know when you joined in the conversation, but I know this was obviously not satisfying to me, and I think I heard Stephen say it too, which was, Trump's attorneys took the position during his second impeachment and I understand, Stephen, there was like quibbling over the timeline. Just want to remind everybody, the Republicans.
No, there was no quibbling. We solved it. There was just a fucking morning chat. Yeah.
I was about to say, they deliberately kicked it out to create this ambiguity in the first place. They could have taken up the Senate trial when Trump was president. They chose not to deliberately. So anyway, during the impeachment trial, Kurt, if you remember, Trump's attorney said,
I do remember.
You can't. Yeah, that you gotta impeach, or you gotta go after them with the Justice Department if they're a former president, because you can't impeach and convict a former president.
Yeah.
Now Trump is taking the opposite position because, of course, he's an unprincipled hypocrite, and would just take whatever's convenient to him at the time. So when that conversation or that tangent comes up during this case, Trump's attorney is like, well, listen, that's just a risk we have to assume. If the illegal conduct isn't known about until after the person leaves office, it's just you're kind of SOL. Do you find that satisfying?
Not entirely. No. I mean, it's just there's just a lot of worries that I just generally speaking, I just worry about what happens next and the precedent and how things can be manipulated and extended and just added to. So, I mean, I have concerns just on every end of the debate, basically.
Is there anything you'd like to see happen? Like, if you have concerns either way, obviously this is going to be resolved one way or another. There's going to be some sort of court decision.
Well,
what would you like to see happen?
Well, if the DOJ believes that they can make this case based on just the purely personal stuff without the official acts, then the easiest way to resolve this is just like, okay, then go do that. Because you by your own admission, and we heard them say it in courts, like we can do it just based on the purely private acts. Like, okay, then go do it.
Yeah, but it's a weaker case, though, right?
I mean, it's a weaker case, but it avoids the problem. And if they think they can do it, which, it is D.C., where Trump would be charged. D.C. is 93% Democrat, so I feel like their odds are pretty decent.
Wait, because I wasn't able to listen to the final third of it. What was the take on the one-legged stool notion, which is, if they, the official act for private gain, where was the final judgment on that? It isn't.
I don't know if that came up with the questioning on the state side, or it might have come up once. I don't remember that, but yeah, it seemed like a weird part about the defense's side.
Yeah, so that would be my question, Kurt. Wouldn't they still have to reference the official act, even if it was for private gain? Wouldn't they have to say that Donald Trump abused, his executive authority? Wouldn't they still have to make that case? Because I'm kind of confused what you're saying. They said they can make the case without referencing any of his official acts.
Mm-hmm. Well, for example, if they think that this, just to the phone call to Georgia, for example, if you want to argue that was not an official act, or he calls the Georgia Secretary of State and says, can you find me whatever number of votes it was? That's not an official act. Then you can just be like, okay, well, here's the phone call he made, and he's campaigning for office, and he's asking to find votes, and has nothing to do with the fact that he's president. It has nothing to do with his official acts. So, there's an example, and I don't know how that would play exactly into the D.C. case, but I would imagine that, with the false slate of electors, it's like, okay, if you want to say that that's not an official act, it's like, okay, here's the phone call he made to whoever, and here's the person he conspired with, and here's the person who was one of the fake electors. Yep, I was recruited in order to be a fake elector and submit fake election documents. It's that has nothing to do with this official act, so you just do that.
Did Sauer concede that him calling Brad Raffensperger in Georgia was a private act?
No,
yes.
Yeah.
Okay, so then here's my follow-up question. If they concede it here in front of the court, would they be obligated to hold that position if if Jack Smith does what you suggest and drops the official acts and goes after the private acts and refiles the case or does whatever he would need to do, is Sauer obligated to take the position? So could Sauer come back and say, actually, no, that was the sitting president, checking in on election integrity during a national election. That was an official action on his part. Can he?
Wait, hold on. Fuck. Some people in chat are saying he didn't.
Oh, okay.
My understanding is he said that he conceded that quite a few things were private acts, but the way that he got around it is he was saying that none of the public gains that they were tied to could ever be brought up in exchange when you were talking about these particular private acts.
The one-legged stool thing. But let's say any of them that he conceded during the argument says, oh, it sounds like a private act. is he obligated to stick with that if Jack Smith does what you say?
Yeah.
And refiles.
Also,
Yeah, I mean, if he actually,
I'll be right back.
yeah, if it's fine. You know, if he actually made a concession, then yes, he's obligated to do that. He is representing his client, and he's making a representation in the court. They are definitely bound by that representation.
Gotcha. Okay.
Yeah.
Interesting. All right.
That is F around and find out on the biggest possible level. Yeah, when you're telling the Supreme Court this is reality, you're stuck with that reality. It's like,
So
yeah.
if he told the Supreme Court this is a private act, they do what you suggest. He files again and then says
It's
actually,
law
no, that was public act.
on a formal level, on a formal legal level, we call it law of the case, right? Because I've made a representation to the US Supreme Court. They're going to issue a decision based on my representation. That now forms the law of the case. And so now that representation, which is baked into the order, is now part of the law of that one case. And so, yeah, I'm stuck with that.
Interesting. Okay.
Yeah.
So what do you think's gonna happen from this? I guess is my last question for you. You think they're gonna?
I think Trump is going to come up with some kind of win. Now, what kind of win, I don't know, because I can definitely see the Supreme Court wanting to kick as much of this down the road as they can. So I can see them wanting
even a delay is a win for him, right? I mean, even if they remand the that's a win, right? Even if it goes exactly the same way, the idea of putting it back to a lower court, that's a win for him because he does not want this to go to trial before the election.
No. And some trials take a long time to go to trial, and whether or not, and they just sometimes percolate for years, even in non-presidential cases. Some cases just take, I mean, there are murder cases where they're 3, 4, 5, 6 years old by the time it gets to trial, just because of all the preliminaries and everything that happens. Things happen, so we don't typically just expedite it because, you know, it would be nice to get this done faster. You know, due process sometimes requires lengthy time.
Yeah, I don't think even after this, I don't think that they're going to grant some sort of blanket immunity. That would boggle my mind. I mean, even if for no other reason, is that would further remove the president from any sort of judicial review by the Supreme Court in terms of, well, at least in terms of potential criminal prosecution, right? That would further immunize one branch of government from the. I don't think they would. They're going to rule in that way. They might do something like you said to try to give Trump a win here.
Yeah.
I have a hard time believing they're going to give him exactly what he asks.
No, I don't think they're going to give him exactly what he asks for.
Especially with the incumbent being a Democrat, you know.
Yeah.
So.
No, I don't think so either. Just a friendly reminder for the chat out there in Destiny's World. My name is Kurt. I have the channel Uncivil Law. I have 129,000 subscribers, trying to get to 150. So if you like legal analysis, legal commentary, legal discussion, that's what I do. Try to produce lots of great content. So head over to Uncivil Law and subscribe today. It is appreciated. Thank you. Cool. Got to get the channel plug out there.
Yeah, you should as often as you can. All right, buddy. I appreciate it. Thanks for answering the questions.
No problem.
The rest of your night.
Yeah, no problem. Bye. Yeah, but I definitely think that we're looking at some kind of win for Trump here, and the nature of that win is where the rubber meets the road. But I think they're going to try to kick as much of this down the road as they can. But I think they're going to. I think the president's going to have some kind of immunity for official acts, and it may not be a complete immunity, but it may require like some sort of heightened qualified immunity, where it might require some sort of specific findings or some sort of specific delineations by the trial court. So I think as a practical matter, the trial court is going to spend a fair amount of time trying to, assuming they're not just cock blocked, I assume they're going to spend quite a bit of time trying to constrain and filter out what are official acts, what are not official acts, giving the proper instructions to the jury and all the rest of it. That's going to take a lot of time. So I think as a practical matter, we are not looking at a trial in D.C. reasonably anytime in the immediate future. That is the best possible analysis I can see based on the argumentation. So it is what it is. Would I be willing to do if I'm wrong? Well, if I'm wrong, then I'd read the Supreme Court's decision and find out why I'm wrong. That's what I do, right? When I make an incorrect prediction, I read the decision of the court to understand why I made an incorrect decision and try to figure out whether or not the court's reasoning is better than my reasoning. And if the court's reasoning is better than my reasoning, I'm like, oh, okay, that makes sense. I'm glad that they explained it to me. Now I'm smarter. And sometimes I disagree with the court. And I'm like, no, I don't agree with the Supreme Court. I think that was an incorrect decision. So that's what I do in legal analysis world. I read the decision and I think. That's what I'm willing to do. I'm willing to read it and think. And then depending on my reading it and thinking, potentially revise my ideas. Yeah. But I mean, just because I disagree with unanimous Supreme Court decisions, quite famously, I've disagreed with Wickard v. Filburn and disagreed with Chevron versus NRDC, both of which are unanimous Supreme Court decisions. And I think the Supreme Court got it completely wrong. So, you know, I'm not afraid to disagree with the Supreme Court when I look through it all and I'm like, you know what? I just think those were incorrect decisions. So that's what we do. Yeah, Wickard v. Filburn is a hell of a case. Wickard v. Filburn, for those of you who might not know, was a case about wheat and how much wheat you could grow. The United States had a law that restricted the amount of wheat you could grow. The reason they had this law was because they were guaranteeing the price for wheat as part of an economic measure. So they said we will guarantee that we, the federal government, will pay X price for the wheat. And then, well, they're like, well, if it's uncapped, people will just grow as much wheat as they possibly can, and we'll have an uncapped thing, and that's bad. So they're like, okay, here's the maximum amount of wheat you can grow. So this guy, Filburn, owned a farm, E-I-E-I-O, and on this farm, he grew some wheat, E-I-E-I-O. And critically, he consumed all the wheat on his farm. He didn't sell any of the wheat. He used all of the wheat. Okay, he used all of it, and so the wheat man came by and it's like, yeah, you're growing too much wheat, and he's like, but I consume all the wheat, and they said, well, you can't do that because we can regulate it under interstate commerce. And he's like, dude, this is a farm, and I'm not selling the wheat. It's not interstate. It's a farm in a state. It's intrastate, and it's not commerce. I'm not selling it. It's non-commerce. So instead of interstate commerce, it's intrastate non-commerce. And the US Supreme Court ruled that he could not grow the wheat. They ruled that the intrastate non-commerce legally counted as interstate commerce because since he was growing the wheat, he wasn't buying the wheat. And because he wasn't buying the wheat, well, that affected commerce now, didn't it? So the not buying things counted as commerce. That was Wickard v. Filburn, 9-0. I hate it. I hate it with a passion. Yeah. Because, you know, if everyone grew their own wheat, well, then people wouldn't buy wheat on the market. People wouldn't go to the store and buy their wheat because everyone's buying wheat, and we need to have a wheat market, so we need to make sure that people buy wheat. So you're growing more wheat than you're allowed, and if you need the wheat because you consume all the wheat, you have to go into the market and buy the wheat you need. You can't grow it. You're not allowed to grow your own tomatoes or wheat or whatever. That was Wickard v. Filburn. I hate it. I hate it with a passion. Yeah. It pisses me off. U.S. versus Lopez, that's the gun control case with the guns near the school zone where they tried to regulate interstate commerce. U.S. versus Lopez was the first case that did not uphold a law under the federal government's interstate commerce authority, like ever. So Wickard v. Filburn was the late 30s, I want to say, and Lopez was like 92. So, Lopez was the first time that the U.S. Supreme Court said the federal government did not have authority under interstate commerce. In Lopez, the federal government tried to ban having handguns near schools because having handguns near schools affected commerce. Because if there were guns near schools, then that might affect the ability of the kids to learn. If the kids don't learn as well, then they might not be as economically productive, and that would affect commerce. So they tried to create guns-free school zones under interstate commerce. The possession of guns was part of commerce. And the Supreme Court said, no, that went too far. That was Lopez. Give us another example of a Supreme Court decision I don't like. Well, there's one right now that's being challenged as we speak that I hope will die a horrible, horrible death. Chevron versus NRDC. Chevron versus National Resource Defense Center. Chevron is the backbone of basically all administrative law as it exists today, and I hate it. It basically says that the administrative agencies are the ones that get to interpret what the law means, which doesn't make any sense, because you have a federal agency, say, I don't know, the USDA, and you ask, and here's a law, hey, USDA, here's what we want you to do. And then you're like, okay, so what is the USDA allowed to do? And guess who gets to make that decision? The USDA. The USDA is the one that gets to interpret the statute that tells them what they are allowed to do. And amazingly, they interpret to give them more power. What are the odds? So every federal agency is the one that gets to interpret what they think the statute means. And then there's some follow-on cases called Auer is one, A-U-E-R, Auer. And then one is called Brand X is another case. So they get to interpret what the statute means. They get to interpret what their own regulation means. And they get to change their mind. So they can completely flip their mind about what the law means, and they're still right. So it's the person you gave power to that gets to interpret how much power they have. That's Chevron. I hate it. And if grace is kind, this term, the Supreme Court is going to strike down Chevron. It might be coming to an end. I have my fingers crossed. I'm very, very excited. How long have I been an attorney? 16 years. Overturn Chevron. Chevron needs to die horribly. Also, while we're at it, can we do something about qualified immunity? Because qualified immunity drives me crazy. Because you need to find it, because in order to sue the cops, for example, because they screwed with you, in order to sue the cops, you need to find it's clearly established. So here's what happens. You sue the cops because they did something to you. Then the court says it's not clearly established, so you can't sue the cops. So they dismiss the case. But because they dismissed the case, it's not clearly established. So then move forward a couple years, and it happens again. And someone else sues the cops and says, hey, the cops screwed with me. And the court says, well, you can't sue the cops because it's not clearly established. But then they dismiss it, so it's not clearly established. And then a couple of years later, another person comes and says the same thing. It just keeps happening over and over and over. They never actually clearly establish the law. It's really annoying. I want to go back to the reasonable officer standard. It was great. The reasonable officer standard is the way we should go. How about the reasonably prudent officer was the great standard? You know, that'll be fine. But this qualified immunity garbage has got to go. Why are we subjected to this guy? Because Destiny loves you, and Destiny wants you to get good quality legal advice from the channel Uncivil Law. That's right. YouTube.com/@uncivil-law. For all your quality legal advice, please go over there and subscribe today. And you get to have more quality legal advice from me, your host, Uncivil Law. Am I a libertarian? No, I consider myself more conservative. I'm consider myself a Republican, not libertarian. In fact, you could do it right now because there's nothing happening on stream. You know, you could open another tab right now as you're speaking, maybe. You could do that. How about you go over to another tab of YouTube and look up the channel Uncivil Law and hit that beautiful, beautiful subscribe button. That would be appreciated. Not happening? Oh, that's okay. Well, maybe another time. Am I still talking? Yes, at the moment, because I'm trying to fill time. I've been left alone, and I'm trying to fill time in Destiny's absence. I'm doing fine. Thank you for asking. I'm having a great day. I've been going to the gym a lot more recently. I've been having a lot of success at the gym. Recently, I did a leg press at 748-pound leg press for 3 sets of 10. So I was pretty excited about that. New PR. Kick ass. Please stop talking, but I'm the only one here. I've got to hold the court. Yeah. Please give us a case you didn't like, but the reasoning of the court changed my opinion. Let me think. A case I didn't like, but the reasoning changed my opinion. Oh, man, I don't know if I can think of anything off the top of my head. I'm sure it's happened. There was a case dealing with whether or not women should be subject to the draft that I thought, where the Supreme Court pointed out that only it can change the law, that I thought was pretty persuasive. I guess that comes to mind. People want, someone on my own chat wants me to tell you the bee fish story. All right, you guys will like this. So one of the things I have on my shelf on my channel, I have a bee that is a fish. Here is the story. The state of California, people in California wanted to protect bees. They're concerned about colony collapse, okay? Now, the state of California has an Endangered Species Act of its own. They have their very own state-level Endangered Species Act. The state-level Endangered Species Act does not protect bees. However, the state law did protect fish. And fish were defined in the relevant law as being mollusks, some other things, other invertebrates, and blah, blah, blah. And someone sued, arguing that bees, being invertebrates, are therefore fish. And the Court of Appeals ruled that bees are legally fish. It was the Almond Alliance versus, I want to say, it was the Almond Alliance versus the Fish and Game Commission. If you want to go look it up in California law, have fun. Bees are legally fish in California. So I have a friend, I call it Callie the Beefish. And it speaks like this. Hi, my name is Callie, and I'm a beefish. And I love you very much. I go buzz, buzz, buzz in the ocean. Buzz, 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 swimming around. Buzz, 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 I'm Callie the Beefish. Callie the Beefish. I like to point out that Callie is a freshwater fish that swims in the ocean. And if you're thinking to yourself, geez, that's a contradiction, I'd like to remind yourself that this is a bee that's also a fish. So your rules of logic do not apply in my universe. Can I explain why a civil judgment can be literally meaningless? Yeah, collection on civil judgments is hard, as anyone who does it tells you. Sometimes it's because they don't have money, and sometimes it's because respective state law provides them a lot of protection. Why didn't they just make a law to protect bees? That's an outstanding question. Why didn't they just go to the legislature and get a law that protect bees? That is a really good question. I don't know. Instead, they got the Almond Alliance with the help of the Xerxes Society, and I'm not making that up. That's their name. The Almond Alliance and the Xerxes Societies teamed up in a lawsuit against the Fish and Wildlife Commission to argue that bees are fish. This is the kind of high quality content you get on Uncivil Law. How did the bee song go again? I go buzz, buzz, buzz in the ocean. Buzz, 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 swimming around. Buzz, 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 I'm Callie the Beefish. Pisco, please save us. Pisco is not here. And I'm not sure what Destiny is doing, but I'm apparently holding the channel down. That's okay. Can I read you a beat time story? I could read you some of the writings of Chad Daybell, who's on trial for 3 counts of murder. Chad Daybell wrote a Left Behind series clone. He's a Mormon offshoot, and he wrote a Mormon-inspired Left Behind series that I've been reading on my stream from time to time. I could read you some of the writings of Chad Daybell. That would be exciting. I sound like Albert Brooks? Thanks, I guess. Can I talk about Karen Reed? I don't really know that much about the Karen Reed trial. They've been having a very hard time selecting a jury, I can tell you that. Do I cover any streamer drama on my channel? I try to avoid streamer drama as a general rule. Was Gorsuch right on Bostock? Yes. I loved Gorsuch's opinion in Bostock. I thought it was brilliant. I really do. I genuinely thought that Gorsuch's opinion in Bostock was absolutely brilliant. Bostock was the case that dealt with discrimination in the workplace as it relates to homosexuality and transgender rights. And Gorsuch wrote this outstanding right-wing opinion about why the law protected gays in the workplace and transgender people in the workplace, and it was brilliant. It was one of my favorite opinions of recent memory, and it was just a very brilliantly written thing. I loved that opinion in Bostock by Gorsuch. I thought it was absolutely brilliant. Frogs or dinosaurs? I guess frogs. Why was it brilliant? Because someone asked me earlier. Someone asked me earlier about a case that I wouldn't have initially agreed with that changed my mind. Someone asked me, "Can you name a case where you wouldn't have thought something, and then the case changed your mind?" Bostock is a case, right? Because the way I read the statute, when you go read the Civil Rights Act of 1964, right, it says, among other things, in Section 7, I believe it is, as memory serves, you can't discriminate on the basis of sex in the workplace. And it's like, well, that means you can't discriminate against someone being male or female. And if someone is gay, then you're not discriminating against them because they're male or female. You're discriminating against them because they're gay, right? Which is not the same thing, right? So, but Justice Gorsuch changed my mind, because what Justice Gorsuch said is you can't discriminate on the basis of gay without also discriminating on the basis of sex. They are one and the same. Because suppose you have 2 employees. Suppose you have a male employee and a female employee. And suppose both employees marry a man, a different man, but they both marry a man. So your male employee marries a male, and your female employee marries a male, right? So the only way that you know that they're gay is by reference to the sex they are. That's the only way you know they're gay, right? How do you know that the male that married the male is gay? Well, because he's male, at which point you've taken notice of his sex. The female isn't gay because they married a male. The male is gay because they are male. But once you do that, you've made a determination of their sex, and now you're discriminating against them on the basis of sex. You're only firing the guy that married a guy because he is a guy. If he were a girl, you wouldn't have fired him because he wouldn't be gay, which means you're discriminating him on the basis of sex. So discrimination on the basis of sexual orientation implicitly requires discrimination on the basis of sex. And I'm like, well, that's just brilliant. That's just brilliant, because you're taking the word of the statute and just applying its logical consequence. And I'm like, that's brilliant. I think it's great. Another good one, incidentally, where I changed my mind based on the arguments was the original cases dealing with gay marriage. Because when that case actually went up to oral argument at the Supreme Court, like initially I would have said, okay, the states can ban gay marriage. But when they actually made the oral argument and I actually listened to the presentation changed my mind. Because I'm like, no, they can't, because you can't, there's no legal reason. I can't come up with a legal reason. So the decision in the case changed my mind. Hey, he's back. Yay.
Hi. you and Pondering Politics have a good discussion?
Yeah, we had a fun discussion. We were discussing different legal principles and things like that. So I can sign off now if you like.
Okay. Well, hey, listen, I love you. It's been fun. And I will catch you for the next legal thing, okay?
All right, good. Until next time. Bye-bye.
Yeah, have a good one. Bye.
All right, good. Until next time. Bye-bye.
Yeah, have a good one. Bye. Okay. We had to do at least an hour of reading today, so we've got like 30 minutes to cover the daily news stuff.
All right, guys, I suppose that will conclude us over here as well on Uncivil Law, having concluded the stream. But you know, that was an interesting experience, having to vamp there for a while. I don't know what Destiny was doing. I guess he was taking a more extensive bathroom break, but I didn't know we were going to be vamping for that long. But hey, we at least had some fun discussions, and we had some fun discussions about law. We talked about Wickard, we talked about Chevron, we talked about Bostock, we talked about gay marriage, we talked about lots of fun cases. It was exciting, and we had a good time. Yeah. Yeah, Bostock was a brilliant case. That made me fall in love with Gorsuch. No homo, lol. But no, that case in Bostock I thought was brilliant. It was absolutely brilliant. Because he made an argument. I'm like, I can't. He's right. It's like I can't beat this argument. It's like, you know, it's just perfect. And the gays in the homosexual marriage too, same problem. Like, the problem with the bans on gay marriage was I couldn't find a rational basis, you know. And I sort of made that decision as I was reading the briefs and the oral arguments, right? So I sort of made that decision. I suppose the oral argument cemented my view. But like, you know, I would have initially said, well, you know, the states can ban gay marriage. But the problem was, I think it fails rational basis review. Right? And we've talked about this a little bit before. It's like, if the government wants to do anything, right, they need bare minimum rational basis. You know, they can't do arbitrary and capricious. They need bare minimum rational basis. And so you need a reason. You need any legitimate reason for any legitimate end. And the problem with gay marriage is I couldn't make it work. I couldn't come up with any rational basis. None of them worked. Because once they started like trying to go through them, I'm like, wait a second, none of these arguments work. It's like, oh, you know, because we let people get married who are old. We let people who get married who are infertile. We let people get married who have no intention of having children. You know, so it's like, what is the rational basis other than just straight animus? What is the reason to prevent this? You know, what is the reason to prevent it? We want to promote children. It's like, okay, how are you doing that with straight marriage? Are you making any effort to ensure that they want children? Are you making any effort to ensure that they are fertile? Are you preventing people from getting married who are too old to have children? Are you doing that? No, you're not doing that. Oh, okay. So your reason is belied, right? You're not doing, if your motivation is we want to have an environment in which people are having children and some sort of protected status, it's like, okay, but you're not doing that with straight marriage. So it's not really your reason. So what's your reason? Right? And nothing works. Nothing works. And so I couldn't make any argument work in rational basis. And I'm like, well, all that's left is animus, and animus isn't good enough. You know, I want to ban gay marriage because it's icky is not a good enough reason. That is not a good enough reason. So what is your basis for the disparate treatment? And I couldn't make any argument work. So I changed my mind. You know, so I couldn't make any argument work. And Bostock changed my mind about discrimination as it relates to gays in the workplace. So it happens. Anything else before I finish off here? I did really enjoy that stream. I hope some people will come check out my channel. And I hope we get some subscribers out of it. That would be nice. Yeah. Yeah, so it's just like, yeah. All right, I guess I'm going to sign off. Well, hopefully some of the people in Destiny will check me out. I plugged my channel a couple times. Hopefully they'll come check me out. That'd be nice if we get some subs out of it. The man does have like 10,000 people watching him. I wouldn't mind a little bit of love over here. How are they doing anyway on syncing up oral arguments for today? Oh yeah, usually isn't that fast. Usually it takes them a day or two. Yeah, they haven't synced it up yet. It's not surprising. So we probably will be on tomorrow with the oral arguments for the Trump case. Yeah, we have Thursday Night Thunderdome. Are we doing that in like an hour? In a half hour? We are doing Thursday Night Thunderdome. Well, okay. So we'll do Thursday Night Thunderdome in an hour. That'll be fun. I always forget that I have Thursday Night Thunderdome. Do I realize that Destiny thinks Trump is fascist? Okay. Noted. I mean, it's a strong opinion, but as long as I can have something resembling an intellectual discussion with him, which I just did, then I'm happy camper. You know, I just had what I would consider to be a reasonable and productive discussion. So I don't really care very much what he thinks. As long as I can talk to him, I'm happy. As long as he has something intelligent to say, I'm happy. Trump for immunity, it's not available yet. I'm going to go ahead and create a live. I'll go do it 7:15. I'll give myself 45 minutes because I need the break. But we'll do Thursday Night Thunderdome at 7:15. We'll do it in 45 minutes. You know, you should be willing to talk to anyone that you can talk with, is my view. And although I wouldn't use the term fascist, I can certainly understand, you know, I can understand negative feelings about Trump. I mean, that's not really hard to figure out why someone wouldn't like Trump. So fascist would be a bit of a strong term for me. But, you know, as long as you have something intelligent to say, and I can literally have a conversation with you, and I can learn something, I'm happy, man. I'm happy. Because then I'll learn something, and I'll be smarter. And that's good. I have tricked you into teaching me. Bwahahaha. Bwahahaha. I have tricked you into teaching me. So, you know? And then maybe someone will teach me something I had never thought of before. For example, Bostock or something like that. Someone will make something. I'm like, oh, I hadn't thought of that before. Oh, okay. And then it'll change my mind, and that'll be good. The only downside is when the other side refuses to do the same. Well, then you can't have a conversation with them. I mean, my ability to have a conversation with them is necessarily implicit on them also being able to have a conversation with me. If they can't have a conversation with me, we're not having a conversation. A conversation is a two-way street. So as long as we can have some sort of exchange of ideas, then, and we treat each other with some modicum of respect, And there's a lot of reasons to be critical about Donald Trump. Rhetorically, he's a bit of a disaster area. He's not doing a lot really to convince, the hearts and minds of people. He's a rhetorical disaster. All right, guys, I will see you in 45 minutes for some Thunderdome. I know you're excited. I'm excited. I will see you in 45 minutes for Thunderdome. I've been on Civil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.